everyone. Good morning. Good morning in the bushes. Good morning, Grandma Sherry. Hello, hello, you guys. So how is everyone doing today? We are going into jury selection day 5. Day 5. Still waiting for them to unmute. Obviously, we still have a few minutes before they are supposed to be here. Good morning, Jane Doe. How are you? I'm so excited that this process is getting on the way. Really hoping that we can get the rest of the people that need to be picked between today and tomorrow. That would be awesome. Hello, Colorado Mountain Girl. How are you? It would be really awesome if they did it today and tomorrow, and then we didn't even have to come in on Wednesday. I'm not sure if that's going to happen though. The judge himself isn't sure what's going to happen. Hopefully we can get lucky though. They only really need 35 more, I think is the number, right? Yeah, I think it's 35. It's either 30 or 35. Hi, Boo Will. Hi, Lynn. Hi, Liz Budler. How are you guys? Hi, Jane Doe. So before we get into justice for Gannon, guys, there is a little girl that I want to bring up to you that's missing. She has been missing for quite some time in Conway, Arkansas, and her name is Tanvi. If you guys haven't seen her before, I do have several videos about her now, just short uploads and also a few things like that. But she has just missed her birthday. She just had her birthday this past week and she's still missing. And I just want to share this out because she's been gone for quite some time now. Let's see, this is her. And she was fearing being deported when she went missing. Let's see, it says Tanvi was a 14-year-old junior high student was reported missing in January when she failed to come home from school. A national campaign will be launched to find missing 14-year-old Arkansas girl who may have run away because she feared her family was going to be deported to India. She disappeared in January and was last seen walking past her junior high bus stop. Her parents said the girl, sorry, let me make this a little bit bigger. The girl, a good student who exceeded academically, had been frightened that her father, a tech worker, was going to lose his job and massive layoffs in that field, her family said. That was nearly 6 weeks ago, and now her mother and father fear the worst. So they say deportation is no longer a concern. The parents posted a YouTube video pleading for their only daughter to come home. This is actually our video here that they had linked. And I did not record this video. I was not the person who did the interviews. There's an amazing, amazing woman who has been advocating for Tanvi since she went missing. And she got with the parents and recorded the uploads. I just re-recorded it and put it onto YouTube. And so, like I said, they shared that video out. It's the message from her parents. If you'd like to see it, I will drop the link, or Grandma Sherry, if you could grab the link to Tanvi's parents' video. It should be under the upload section. It says, "We are missing you every second," the mother said from the family's home in Conway. The National Center for Missing and Exploited Children announced it's launching a campaign to find the girl, with her face being flashed on gas pump screens throughout Arkansas, Texas, Oklahoma, Tennessee, and Missouri. So the law enforcement case manager said, "You wish every community with a missing child would respond the way Conway has. Their community has done absolutely amazing," including an article that was posted in their paper today. So let me share this. This is what I wanted to show you guys. Hi, Vanessa. Yep, we just started, and I'm just sharing a little bit about Tanvi, depending on who you talk to. I try to say it both ways, honestly, because I'm not sure the correct way. But she has been missing since January, so I just wanted to share this before the judge comes in. So this was from today's paper, and it says reward increase for girl in Conway. So her reward is now up to $25,000. The reward for information leading to the safe return of missing Conway teen has been increased to 25,000, community organizers said Sunday. When a child is missing, there is no such thing as somebody else's child, a Conway resident, local organizer Jenny Wallace, and that's actually who recorded the interview with the parents that I uploaded. Jenny Wallace said she belongs to all of us, and it's going to take all of us to bring her home. Someone knows where she is, and we desperately need them to come forward. We are hopeful the reward will motivate someone to provide important information. The reward increase was announced at a birthday celebration Sunday, which was yesterday, for Tanvi, who was last seen January 17th, heading north into Davis Street.
1358.
So court just came in, so we will look at this again later.
Good morning, ladies and gentlemen. Oh, come on, it's a Monday. I know it's Monday, it's hard, but hey, we're into spring. Allergies are up. It's great. Good morning, ladies and gentlemen. My name is Greg Warner. I'm District Court Judge for the 4th Judicial District.
Before we begin the jury process, I would like to introduce some of the people who are in the courtroom and who you may or may not have already met. You see my court reporter up front. Excuse me. It's her responsibility to make sure that everything that is said in the courtroom is transcribed into what we refer to as a record of the proceeding, so that anything that is said by you, the lawyers or witnesses, is made part of the record. That's really important to remember because she can only take down what you say. She can't take down a nod of the head, and uh-huhs and uh-uhs don't get translated very well either. So if you can give a verbal response, that'd be really helpful. In addition, I imagine everybody back here, when they came in, was thought to themselves, I'm really glad I'm not sitting up there. But understand that we're going to be asking questions of everyone in the courtroom as opposed to just the people in the jury box. That's important to remember because the courtroom's really large and it's really hard to hear the people in about the last 3 rows. So if you can speak up, it will make her job a lot easier. In addition, you've also met Mr. Sproul and Mr. Combs. They are here to assist you. You can talk to them regarding any general matters such as parking or phone calls. However, do not talk to them about this case and they will not talk to you about it. They're not being rude. It's just that no one is permitted to discuss this case with you. I assume that most of you were probably not thrilled when you received your invitation to come down and join us this, excuse me, this morning. However, please understand how important all of you are to our judicial system. I do want to thank you for being here, and you should know that the United States conducts approximately 90% of the world's jury trials. Many other countries do not trust their citizens to perform these kinds of decisions and leaves those decisions to be made by some member of the government. However, when our country was formed, the people who formed our country believed that the government should not have that much power. As a result, they placed in our federal constitution, and our state constitution has a similar right, to a jury trial. That right cannot be secured unless all of us have the obligation to serve when called. In case you're wondering, yes, I have the same obligation. Yes, I've been sitting in the same seats that you're sitting in. I do understand that it is a sacrifice for you to be here and put your lives on hold. Thomas Jefferson once said, I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution. I've spoken to hundreds of jurors over the years, and although they told me that it was a significant sacrifice, they told me that they were glad that they had served. They said that it gave them a better understanding of how our judicial system works, how important all of you are to it. And they said if given the chance again, they would serve again. We are identifying you by number in court rather than by name for a couple of reasons. First of all, due to the number of jurors being called, we do not want there to be any confusion regarding who we are talking to at any particular point in time. There may be more than one Mr. Martinez or more than one Ms. Johnson. Because of that, it is easier for our staff to keep track of you by number. In addition, while the defendants, the attorneys, their staff, and court personnel will know your name, referring to you by number is to protect you from contact by the media or other persons, curiosity seekers and the like, to protect you from unwanted publicity, and ensure that no outside information is communicated about you through this process and the trial. Finally, after talking with a lot of jurors over the years, they all told me that they were more comfortable when they were referred to by a number in open court rather than a name. The fact that we are identifying you by number should have no impact at all on the presumption of innocence that the defendant is entitled to, or any impact in any other way as you consider and decide this case if you are selected. The case we're about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. The prosecution in this trial is represented by Michael Allen, Dave Young, and Angelina Gratiano, who are attorneys with the District Attorney's Office. The defendant or accused is Letecia Stauch. She is represented by Josh Tellini and Will Cook. The charge against this defendant is contained in what is referred to as an information and complaint. An information and complaint describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with the deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as jurors in this case? All right, go ahead and have a seat. Thank you. Before we go any further, does anyone have any difficulty either hearing or seeing what's going on in the courtroom? All right, no response. In this case, 12 jurors and 6 alternates will be chosen. They will consider all the evidence produced during the trial. The jurors will determine what the facts are based on the evidence in the case. The attorneys anticipate this case will take approximately 6 weeks for trial. That does not include deliberations or jury selection. We hope to start the presentation of evidence on April 3 of 2023. So that would mean finishing sometime in mid to late May. I do understand the burden such a lengthy trial places on people. I previously presided over one that was 18 weeks long from start to finish, so I do understand. Our trial days will generally be from 9 to 5, Monday, Tuesday, Wednesday, and Friday. There will not be any trial on Thursdays, as I have other docket matters that I have to attend to. You will be able to go home to your families each day. And though you will not be able to discuss anything about the case or the trial with them, you will be able to talk to them about anything else. Knowing this time commitment, is there anyone who believes they would suffer an undue or extreme hardship if required to serve for this trial? Please raise your hand. I'm going to start in sections, so I'll start over here first. Juror number 1, did you have your hand up? Yes, ma'am.
On something that impacts a major audit, and it's a big audit. That's what I can.
What's the company?
Government contract company.
Okay. Well, one of the reasons why I asked this specifically is because government, especially government companies and large companies, also have a policy whereby they understand jury service and continue to pay for jury service and continue to do all those things.
Big one that can impact. I'm senior lead, so it can impact the company.
Okay. And you don't want to tell me what the company is? I mean, is there some top secret issue or what?
I'm not sure that I can. I can tell you, but to know what is happening to a major company,
Okay.
can lead to other things. So happy to tell you.
All right.
But understand that's not public.
Okay. All right. Anyone else in this back row? Number 2, juror number 2.
Difficult
Okay, and I'm just going to ask, how old are your children? So the 4-year-old is not in school or is in school? Okay, because we do have court care that's available, if that would help. Is that the 7-year-old? Okay. 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 Juror number 3?
I live over an hour away. Driving to town.
We are a big county. Okay. Juror number 4, did you have your hand up? Yes, sir.
I do not. I'm currently between two. Every day.
Help me understand. You're currently between what does that mean?
I don't know.
Oh, okay. Anyone, juror number 5?
Self-employed, and my business relies heavily on spring and summer months to survive. During the winter and the colder days, business doesn't do well at all. So it's a big,
You're a landscaper?
right.
Okay. Got it. And Food Truck Tuesdays start in May.
Tuesdays and Fridays are my best days.
Okay.
Weather's great.
All right. Anyone, juror number 6? When is the cataract surgery scheduled? Okay. Anyone, juror number 7? Oh, when is that? When are you going to Australia? Okay. Juror 8, did you have your hand up? No? Juror 9? Okay. Juror number 10, did you have your hand up, ma'am? Okay. That's on the questionnaire. Okay. Front row. Hands in the front row. Looks like juror number 15. Yes, sir. Yes, sir.
I'm a lead on a team for a major defense contract. We have 3-month planning cycle coming up. I'm the point of contact for communication with other teams, it would just be kind of a major burden on the other leadership in the team, if you will.
Okay. Anyone else in the front row? All right. In this section over here, front row. Juror 25. You're actually juror 25. We take it through by seat number. So that's why we started with number 1 in the far back here. So no, it's okay. You're not the first, this isn't our first day doing it, and you're not the first person to have done that. So it's all good. Okay. We might be able to deal with the no car issue. Tell me a little bit about the unemployment. Are you looking, or what's going on with that?
I live,
Okay.
goes to work. I have a ride.
What general area of town do you live in? Okay. We have on occasion arranged for taxi service, but that was on a shorter trial. So that's just what I was thinking about. Juror 26, did you have your hand up? Yes, ma'am. Okay. Juror 27, did you have your hand up? No? All right. Juror 35, and yes. Okay. Anyone else in that row? Juror 40? Yes, sir. I don't want to get into it in great detail. Have you had heart issues before? Okay. And when is that appointment? Anyone else in that second row? On the end, juror 41. Where are you going to school? Right. Anyone else in that second row that I missed? No. Anyone in the last row over here? All right. And it looks like juror 53 in the white sweater. All right. Juror 54. Yes, sir. All right. Okay. Juror 55, did you have your hand up? Yes. How old are your kids? Okay. And then first row over here, juror 28. Okay. And did you say you were moving in 2 weeks or you're just changing jobs in 2 weeks? Okay. Juror 30. Yes. Right. Anyone else in this? Juror 31. Okay, this Friday won't be an issue. Tell me what um, the conflict is in May. You said that there was it training? What is that? Okay. And the court hearing that you have in April? Okay. Do you know what day it is? Won't be the 15th because that's a Saturday. 16th is a Sunday. Do you remember what day of the week it is? Okay. All right. Anyone else in the front row? Second row. Juror 42 on the end. Okay. All right. Who else? Juror number 43. What kind of work do you do? Anyone else in the second row? Looks like, let's see. Juror 46 with your hand up. Yes, ma'am. All right. Juror 47, did you have your hand up, sir? Yes, sir. Like in 4 months. Okay. All right, Juror 48, did you have your hand up? Yes, sir. All right, and then in the next row back on the end, Juror 56, do you have your hand up? Yes, sir. What kind of work do you do? Anyone else in that row? Juror 59 in the middle, yes, sir. We can do that. And that's why I was asking some questions of the young lady that was a couple of rows ahead of you, because we've always had, or we've never had difficulty with military individuals, and I can get you a letter that help. Okay. Juror 62.
I don't drive for medical.
And generally, where do you live? Row, not on the back wall, but the one in front of that. So. For 67, yes, ma'am. Sorry for your loss, ma'am. And then the far back row. Juror 70 over here on the end.
Sorry, I can't hear you.
Can you speak up? Are you on break this week or was it last week? Else in the back row? I can't tell. Put your hand way up because I got heads in the way. There we go. All right. 71. Right. Juror 73. And juror 75. I'm sorry, I missed the first part. And how old are your kids? All right, I also need to go through a list of grounds that may disqualify you, and you should raise your hand if any of these apply to you. Do any of you believe you are related to the defendant or any of the attorneys? Please raise your hand. No response. Please raise your hand if you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of, or a partner in business with, or surety on any bond or obligation for the defendant? That's a long lawyer question, but essentially what we're looking for is, do you have any particular relationships with the defendant? Does anybody think that they're in that category? No response. Are you now or have you been a party in a civil lawsuit involving the defendant, or have complained against her or been accused by her in a criminal prosecution? Anyone think they're in that category? No response. Do any of you believe you are a witness to any matter related to this crime or its prosecution? No response. Do any of you have a personal or financial interest in the outcome of this case? No response. Do any of you have any feelings or a bias for or against the defendant or the prosecution? Please raise your hand. Juror number 19. Yes, ma'am. Okay. What we're looking for is sometimes we had one just not too long ago where someone was being prosecuted by this particular district attorney's office. And because of that relationship, none of these lawyers, but because of something that happened with them, they had a bias against the prosecuting attorney. Sometimes you will also see it as I have a bias against law enforcement, or I have a bias against these prosecutors. We had one gentleman that was actually prosecuted by one of the prosecutors that's sitting at the table, and felt a little bit odd about that. So it's something like that. Does that answer your question? Okay. Are any of you an employee of any public law enforcement agency or the public defender's office? And looks like we have, you went like this. Does it really count? Was it up? Did you mean it? Okay, juror 48. Okay. We're going to excuse you and thank you for your service. Yes. And juror 69. Okay. You said you're a detention deputy for who? So is it El Paso County Sheriff's Office? Okay. Thank you for your service. You're excused. Anyone else? No? All right. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they're in that category? No response. Please raise your hand if you're unable to read, speak, or understand the English language. Anyone think they're in that category? Response. Please raise your hand if you're incapable due to physical or mental limitations to render satisfactory jury service. Anyone think they're in that category? Juror number 9. Okay. Anyone else? No response. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household, such that your service would create a substantial risk of injury to the health of that disabled person. Anyone think they're in that category? No response. Please raise your hand if you have served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Anyone had any jury service for 5 days or more in the past 12 months? No response. All right. Some checking here. $60. And it was juror 69 that was the EPSO officer that was excused. All right, what we're going to do is take about a 10-minute recess. What I need for all of the jurors to do is to head out into the hallway. When we come back, I'm going to excuse a number of you, and then we will proceed on with others and further instruction at that point in time. Before you go, wait. Before you go, remember where you are, because we follow the third grade seating chart. So when you come back, you want to make sure that you're sitting in your seat and not somebody else's. All rise for the jury, please. Sorry. Yeah, you can leave anything you want here because you'll be coming back. So you can take it with you or you can leave it here. It's up to you.
Satian, I'm so sorry. I'm trying to figure out how to undo this. I'm an idiot. I am so sorry. I gotta figure out how to like change my settings so that I don't bump that so often.
Sure, I had missed it.
I don't know, Seal. It's better almost whenever I can blame a moderator. Sometimes I can't though, and that stinks. I'd rather blame you guys. Oh man. I don't know if he's going to talk or not. Sometimes they talk through this period. He didn't mute, so there's a pretty good chance he may. But what they'll do is they'll come back in and he'll dismiss everybody that had their personal reasons basically to get out of here, which sounded like a good bit, but we're already down one. So we'll see. I don't know. I think we're going to go a lot quicker through this, and that's good, but I know that we also have gone through this quicker already in other days, and he just extends the breaks. So it's kind of lame. I really wish there was a way to undo that, Emily Flotilla. That would be nice. Really wish you were on the jury. I would tell anyone who kills is insane, but that doesn't make him not guilty. I agree, Team Tina. I agree. You have to have a special type of evil inside of you to kill a child, I think. But insanity, like no sane person would do that, in my opinion. But I agree that that doesn't make you not guilty of your actions. You still
Okay.
did it.
At this point, I'm going to excuse juror 1, juror 2, 3, 4, 5, 6, 7, 9, 10, 15, 25. I have that right? 2, 3. Yeah, that's right. Okay. 26. 35. 40, 41. Yes, 40 and 41. We already excused your 48. 53, 54, 55. Uh, 28, 30, 42, 43, 46, 47, 56, 62, 67, and we excused her 69, 70, 71, 73, 75. I left. Juror 31 is an active duty military. She says she has 2 hearings. I may inquire further about that. I'm not as concerned about the field training, and which is the same reason why I did not excuse Juror 59. He said as long as he had a letter, he'd be okay. Right. So that's where we are at this point. So we'll bring the jurors back in. And I will come down and excuse a bunch of them. $33 down. Oh. Stay with the same ones. They will always be, whatever numbers they have here, they'll always be the same.
Ringo,
matter
I
where
was
they
just
are,
getting ready to
right.
say thank you for counting and doing math for us, but I had already typed it. Almost every day, though, I have to have somebody check my math, so thank you.
So.
I'm being smart today and I'm actually keeping notes for myself because I have like almost the last like all day I guess it would have been Friday. I was like, "Oh my gosh, what number are we at?" So this time I'm keeping notes. Okay. It wasn't me that time, Sassy Ann. It's how you're typing. It's this. It's the S. You're misspelling my name, and Battissimo thinks that you are swearing. I just watched it happen that time. So you're missing an E in there. That's like a swear word in the
Thank
UK
you.
or
Good morning.
somewhere. I
Thank you.
think.
Have a great Monday.
Thanks, you too. Okay. Probably look right.
To be completely honest, crime curious, I don't trust anyone with my kids. I struggled to even let them go to like Sunday school and stuff like that. And so that would probably be hard for me. I would have to like be there and see the court care and see how it works and know that there was cameras watching
So at
and
this point, we're going
all
to
of those
excuse
things.
Juror 1, 2, 3, 4, 5, 6, 7, 9, 10, 15, 5, 6, 30, 35, 40, 41, 6, 7, 5, 5. So if you're excused, you can leave with thanks to the court. You do not need to go back to the jury assembly. Juror 11? Wait, is that juror? No, wait. You were not excused. Yes.
Good to know. Jules, I don't
Thank
know.
you.
I
May all be
still would
seated.
have a hard time.
I know that we have excused a lot of people, but and you can spread out a little bit more, but you got to stay in the same pretty much area because we're still following the seating chart. So you can't change rows or things like that. And I know that's hard for these people up here because you guys are sitting in a hole. And it feels a little bit weird that you're sitting down lower than everybody else in the jury box, but that's the way that it is constructed. So at this point in time, I'm going to allow the attorneys to give a short mini opening statement about what they anticipate the issues in this case will be. It's not necessarily what you'll find them to be if you are selected to serve as jurors in this case. So with that, prosecution.
January 27th of 2020, Tanvi Stauch was at home in the care when he was brutally murdered. He was stabbed multiple times, upper force object causing his skull to be fractured. Shot one time to the jaw, killing him. That triggered 2 other times. No shell casings were ever seen. In fact, that scene was cleaned up and cannon was stuffed into a pendant. You to find the defendant guilty of murdering the up on January 7th, 20 here in El Paso.
Thank you. Mr. Cook?
Ladies and gentlemen, good morning. What said out of the I hear that Shannon Stauch was a way stepmother. She was or Gannon went missing, that Miss Stauch was having some problems.
All right, in this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I will give you. I think a couple of those instructions or concepts are important to talk about right now. The law is that every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. This means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. That's because no evidence has been presented in this case, and nothing that the attorneys say is evidence. Evidence is, you'll see it in the form of exhibits, photographs, charts, diagrams, those sorts of things, or someone who comes up here, comes in front of me, raises their right hand and takes an oath to tell you the truth about the things that they know. The attorneys never do that. They are paid advocates trying to persuade you to a particular position to have you believe that the evidence either does or doesn't show a particular thing. So nothing that the attorneys say is ever evidence. In addition, someone may ask you whether or not you think the defendant has done something wrong, or else she wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in a courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against this defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed this crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome the presumption beyond a reasonable doubt, you must continue to presume that the defendant is innocent. Stated differently, unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. That's what the presumption of innocence means. You may also find it useful to think of these charges somewhat similar to a recipe from a cookbook, because when you actually get the verdict form and the charges, it will have certain things in them that must be proven, sort of like ingredients. Now, for instance, suppose that you wanted to have a Denver omelet and you took some eggs and you scrambled them up and you added some ham and you added some cheese and you added some mushrooms. You might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges a Denver omelet, that's what they have to prove and not something else. No substitutions on the menu are allowed. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? Everyone wants to hear both sides. That's something that we do in our daily lives. However, that's an improper question because that's not the process that is followed in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. The defendant has no obligation to disprove the government's case. Stated differently, the defendant does not have to produce any evidence or any testimony. In fact, defense counsel could, I suspect they won't, but they could take a nap or they could play cards at defense counsel table, and it would not change the fact that the prosecution has the burden of proving every element of the charges that it brought beyond a reasonable doubt. In addition, every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That is because it is not evidence, does not prove anything, and must not be considered for any purpose. Now, sometimes you will hear people talk about the right to remain silent. You will hear attorneys sometimes ask questions intended to elicit a response such as, well, I know if I were accused of something, especially if it was something bad, I would make sure I took the stand and told my side of the story. As I indicated earlier, however, that's kind of a trick question because that's not the process that we follow in a court of law. In addition, does anybody know what the number one psychological fear is in the population? It's higher than a fear of death and greater than a fear of running into a rattlesnake on a hiking trail. Anybody guess? It is the fear of public speaking. So naturally, our process is to bring in 75 strangers, pack them into a courtroom, and start asking them a bunch of questions that they have to answer in front of each other. And I want you to think about that process for a minute. Were you a little uncomfortable? Would you have rather have been someplace else and avoid the whole process? And you hadn't even been accused of doing anything wrong. And you weren't being questioned by the attorneys, and a jury wasn't looking at you while all of that was going on. The bottom line is that it's possible that the defendant won't testify. It's possible that the defendant will testify. But regardless, of who testifies and who doesn't, the question is always the same. And that is, based on the evidence that has been presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt everything that it's required to prove? Is there anyone who thinks that they cannot follow that process? Please raise your hand. All right. Juror number 8 in the back. Yes, ma'am. What's on your mind? Okay. That might be a little bit different. Let me ask my question differently, okay? Because, and we're going to get to that in just a moment. We're going to ask about publicity and about the facts of this particular case, okay? My question is, do you think that you would have to hear from the defendant in order to decide the issues in this case? Okay. And would you be able to give the defendant the presumption of innocence that she is entitled to under the law? Okay. And is that because of something that you may have heard, read, or seen, or something that you know about the case? Okay, so probably media or something like that? Okay. And would you be able to put that aside and decide this case based on what you hear in the courtroom? Okay. And you said you weren't, it sounds like there's not something specific that comes to mind, but you have in mind something that you read, saw, or heard in the past? Do I have that right? Okay. And I'm going to ask you to hold on to that thought. We're going to come back to it. It's a little bit different, but there's an area that we cover it. Juror 19, did you have your hand up? Yes, ma'am. Okay. So for you, the issue is that this case involves a child. And I understand that. I preside over all kinds of cases. So I understand that. Okay. Anyone else in this group? Juror 17?
I kind of have a bias for children. Record, it's not that she didn't do it, it's the fact that she's sane or insane. I honestly have a bias on that. Regardless, evil is evil, so that's my opinion on that.
Okay. And again, that, I know it's hard for the jurors to separate it out. Excuse me. But that's what we do as lawyers. So I understand and I appreciate your opinion. I'm glad that you shared it. It's on a little bit different topic because it sounds to me like the issue for you is the sanity or insanity. Do I have that right? For you, the biggest issue in this case is the fact of an insanity plea. Okay. And you also have an issue that the victim in this case was a child. Anyone else up here? Right in the back, first row, juror 22. Can you repeat that, juror? Anyone else in that first row? Juror 24. And the question really is, I mean, some cases have media and some don't, and some cases have more media than others. And I don't know why that is. I just know that it is. What I can tell you is that the law is it doesn't matter whether you've seen the media or not. The real question is because none of that is evidence, okay? And the media has reported on whatever it is that they report on. It's possible that they didn't get it right. I don't know what stories that you're talking about. It's possible that they didn't have all of the facts in the story either. It may be that they did it as part of something else, and there was, I don't know, some slant or bias or whatever. The question is always whether or not you think you can put aside whatever it was that you read in the media and determine this case based on the facts that are presented in the courtroom. Do you think you can do that? All right. And was there anyone else in that front row? Second row? Juror 37? Yes, ma'am. Anyone else in that second row? Last row, juror 49 on the end. All right. And I saw, oh, there we go. Thank you. Juror 50. Okay, so let me just make sure that I understand your position. For you, it's not media, it's not child, it's the insanity part? Okay. And in this case, if you're selected to serve as a juror, there's an instruction about what you do or and how you find and how you determine sanity. There's likely going to be expert testimony regarding that. You've already heard that they may be bringing in a particular witness. The prosecution would have a witness as well. And those experts would give you their opinions about whether they think that Ms. Stauch was or was not insane at the time and why they thought that. Now, I will tell you that an instruction that you would receive is you can believe all, part, or none of an expert's testimony, just like anybody else's testimony. What you choose to believe is entirely up to you. The question is, and I know this is really hard because you don't have the instruction and you've not heard the evidence, but the question is, do you think that you could follow the court's instructions regarding that, listen to the evidence, and make a determination? Okay. Okay. And then over here, first row, juror 29. Okay. And again, you haven't heard any of the evidence yet. Okay. And so it could be that like I said with juror number 50, you would read or you would receive an instruction on that about what constitutes or how you determine insanity. And the question that I have for you is, do you think that you could follow that instruction? And however you weigh the evidence is entirely up to you. Do you think that you could follow the court's instructions regarding insanity and make a determination? Okay. Anyone else in the first row? Second row? Third row? Let's see. Juror 60, did you have your hand up? Yes, sir. And the next to the last row, are there any hands there? Oh. And the back row, any hands? No response. Okay, thank you. All right, and let's see. All right, some of you have, and we got into this a little bit, but I just want to make sure that the record's clear on it. Some of you have said that you have heard or seen something in the media about this. And my question for you is, even if you have heard or seen something in the media, the real question is whether or not you can put that aside and decide this case based on the evidence you hear in the courtroom. Is there anyone who thinks they cannot do that? So let's see. Let's have hands up again. 19. First row. I'm sorry? Yes, because it's any source. It doesn't matter. It doesn't matter whether you heard it from friends, could be that you saw it online, a Facebook page, anything like that. Okay. Let's see. And so did you have your hand up, yes or no? No. Okay. And juror 23, you did. Juror 24. And in the back, juror 37. Oh, you do have your hand up. Okay, wasn't sure. You guys can put your hands down over here. Thank you. All right, thank you. You can all put your hands down now. Thank you. Juror 38, sitting next to the gentleman in the white hoodie. Yes, you had your hand up, and I don't think I talked to you before. What is it about the media that is causing you a problem? Okay. Okay, so you, not only did you see some of the media, you lived in that area?
I'm sorry, could you repeat that?
Okay, and did you see any of the, did you have conversations with people in the neighborhood about it? Okay, so for you, it was primarily through media and coverage stories and things like that? Okay. And again, you're in the best position to know. My question for you is, do you think that you can put that aside and decide this case based only on what you see here in the courtroom? Okay, no, we appreciate that. And juror number 8, I think we're circling back now to what you had. Tell me what's going on.
I like to think that I can be fair based on the evidence that.
Okay. Okay, so that I'm clear on what you're trying to communicate, you believe that you can set aside the media coverage or you'll do the best that you can to set aside the media coverage and decide this case based only on the facts. Yeah. And then we had a conversation earlier. Are you able to give Ms. Stauch the presumption of innocence that she's entitled to? Okay. And what's in your mind? What's holding you up? You had some hesitation there. Mhm. Okay. Okay. If I understand, then it sounds like what at the core is bothering you the most, or has what seems to have the most impact on you, is that the victim here is a child, and it's the nature of the charges in light of the victim being a child. Okay.
Get what I really meant.
It's okay. All right. Um, let's see. I'm going to ask the jurors to look around the courtroom, and the question that I'm going to have for you is, do any of the potential jurors know each other? Okay, good. No hands. Oh, did you raise your hand, or were you, okay. All right. Just wanted to make sure. Every once in a while I get one hand, and that always leads to an interesting conversation. So, all right. What we're going to do now is we're going to hand you out some sheets, and it's got a lot of witnesses, a lot of names on it. These are the people that we anticipate may be the witnesses in this case. So I want you to look through all the sheets. And the question that I have for you at the end is, do any of you know any of the potential witnesses in the case?
They're always so quiet while they're reading. Yeah, it's hard. Everybody knows she's guilty, right? Gosh, I really wish that he would get something for his throat, though. He has been clearing his throat the entire jury selection process. Yeah, I think so too, Andrea. Is it Andrea or Andrea? I'm gonna make sure I say it right. Welcome, by the way. Yeah, he must have allergies. Probably. Probably. I really I'm so tempted to comment on this WebEx, like to open up a separate one with a different sign in or something and comment on it and be like, please fix the microphones for the second half because the lawyers are going to be talking and we're not going to be able to hear them again today. And that's so frustrating, especially the defense side. Like we can see the first, or we can hear the prosecution, but I'm almost more interested to hear what the defense has to say. and the people that they're questioning and why. Since it's an insanity case, though, aren't we to assume she did it, but she was insane? So we talked about this at the end of, I think it was Friday's stream. And even though it's like considered an affirmative case, an affirmative
Counsel approach,
plea.
please.
Oh, hold on. He's going to counsel approach. Uh-oh. Can he hear us? Fix your microphone, Judge. Are you listening to my stream at the same time? Is that what's going on right now? I know. Is there a clerk at the court you can email? I'm going to look, Emily, because there's got to be something they can do. So they say, yeah, Crime Curious, you're right. The DA's office is watching on WebEx to make sure that they aren't overheard while they're whispering and stuff. And I understand that need for privacy as well. But what's the point of streaming this if we can't hear them at all? I mean, I didn't think it was intended to be just heard by just the judge. Like, I didn't know that that's what we
In
were gonna
addition
get.
to those, did we get everybody? Oh, we'll get back to you. Hold on just a moment. We're getting there. In addition to those witnesses, does the prosecution anticipate calling any other witnesses?
No, Your Honor.
Defense?
Possibly Dr. Rhonda Niederhauser, or possibly Caitlin Craig.
All right. Does anyone know any of the potential witnesses in this case? And so I got to make sure I'm in the right row. Juror number 68. Yes, ma'am. Who do you know? And you said he's a neighbor? Any lay witness or?
We'll be calling that person for sure.
Sorry?
We will for sure be calling that person.
Okay. And how well do you know Mr. Bauman? Can you speak up a little bit? Okay, if Mr. Bauman, and it sounds like he is, as I'm looking at this, that's the detective with the El Paso County Sheriff's Office. Let me start here. Did you know that he was with the Sheriff's Office? And how often have you seen Detective Bauman? Okay. If Detective Bauman were to come in and testify, and it sounds like probably he will, and I don't know how important he is or how long he'll be or anything like that. Some witnesses, what happens here is when they put the list, is that easy for me to say? When they put the witness list together, they put everybody on it that they might possibly call. So you have everybody from, I'm probably not going to call him, to I am going to call him, sounds like they are going to call him. And then you have everybody from, I'm only here for one particular piece and it's not going to take very long, to somebody who might be on the witness stand for days. So the question that I have for you is, do you think that you could judge Detective Bauman's testimony just as you would judge anybody else's testimony? Or would the fact that you are his next door neighbor, is that right? Would the fact that you are his next door neighbor impact the way that you judge his testimony? Okay, that's a good way to put it. That's what I needed to know. Thank you. Anyone else? Juror number 12. Yes, ma'am.
Dentist.
Okay, and how do you know her?
I work at UC.
How long ago was that? How long ago was that? Oh, you work there.
I'm a security officer with ICE.
I misunderstood you. I thought you said you worked there.
No.
Still there. Okay. And so it sounds like this is pretty much in a professional capacity.
Yes.
Okay.
I know who she is. I don't know her that well.
Okay.
But I do know who she is.
And if she were to come in and testify about some aspect, sounds to me like she's a nurse. Not exactly sure what the aspect would be, but if she were to come in and testify, would you be able to judge her testimony just as you would anyone else's testimony?
Yes.
And then juror number 13, did you have your hand up? Yes, sir.
I recognize two names on there.
Okay. Who do you recognize?
It was Celeste.
Okay, let's start with Alvarado first. How do you know her?
I would have gone to high school.
All right. How long ago would that have been?
That would have been, I graduated 2007.
Have you seen her since then?
No.
Anything about that you think could cause you any difficulty if she were to serve as a witness in this case?
No.
And then I'm having Bronco flashbacks. I know you didn't say Von Miller.
No, Ben Miller.
Okay, Van Miller. Okay. And who did, how do you know him?
Another person I went to high school with and church together as well. As if it's the same.
Okay.
Pretty common name.
And you said you were close friends with him?
Yeah.
If he were to, and I don't know what his capacity is in this case, if he were to be called to testify as a witness, would you be able to judge his testimony just as you would anyone else's? Okay. And when was the last time that you saw Mr. Miller?
It would have been
Okay.
10 plus.
So I,
Question and
okay. What I'm fairly confident in telling you is that whatever he would be testifying about occurred after the last time that you saw him. So, because it would have been within the last 10 years, right? So whatever he's testifying about, I don't know if he's an eyewitness, if he's just somebody that says I saw somebody on a certain date, something like that.
like she said, I would believe him based on this
Okay.
character. So.
All right. Council approach, please.
Sorry, guys, looking for.
All right. We're checking. We are not sure. We think it's probably not the same person.
Okay.
Not meaning to be indelicate. How old are you, sir?
34.
So he would be roughly the same age?
He would be 36.
36. Okay, thank you. We're going to look into that and try and get some more information. Okay, thank you. All right. Is there anyone that I have missed? No response. Sure. How old is he? So he'd be about 40. Okay. All right. Thank you. Juror 24, if I can talk to you, nope, gentleman next to you. There you go. Yep. Juror 24, I want to talk to you for just briefly because you had your hand up a couple of times, but I don't think we spoke. You said for the impression that I had was that for you, it was the fact that it was a child and media was involved in this case. Do I have that right?
Well, not me, I just held in the insanity thing.
Okay. So for you, it's the child and the insanity plea. Okay.
You know, for the record, I think that's true.
Did I
I
say?
think you said 24.
That is, that's juror 20. Oh, that's right. It is juror 23. I'm sorry. Okay. Okay.
It's Monday.
It's Monday, and for us, it's like day 5. So, so I apologize for that. Okay. Juror 24, it was child and the and media exposure, right?
Right. I get out of here.
Okay. Okay. Okay.
Sure, what, I'm sorry?
29.
Terry Sanders.
While they're doing that.
Oh, that was a trip. I was thinking.
Okay. And where are you going?
It's Vegas. We can.
Well, then you need to tell me.
It's okay. You can, the more I think about it, I don't think we're even going, so it's okay.
Okay.
Yeah.
All right. Okay. Just need And I'm sorry, Juror 68, I meant to excuse you, I'm sorry. Juror 68 in the back. Detective Bauman. Counsel approach, please. All right, ladies and gentlemen, here's what we're going to do. We're going to take a recess until about 1 o'clock. We've been going through this for about 5 days now. We're getting a little bit faster each and every day. But the attorneys need some time to go through the questionnaires. And when we come back, what will happen is that they will start with their questioning of everybody in the courtroom. You have probably already guessed, you have probably already guessed that there has been some public or media interest in this case. There could be more in the coming weeks. You must guard against that, as you will be required to decide this case based on the evidence presented in the instructions that I give to you. So here's what you can do. When we take our break, you can tell your spouse, significant other, somebody who's interested in your general welfare, that you may potentially be a juror in this case. You can tell them what the case is, and you can tell them that you can't talk to them anymore about it. You can tell them that it's maybe going to go about 6 weeks, but other than that, you can't talk to them about it anymore. Tell them that the judge said that you can't do that. That puts the burden on me as opposed to you. I know that when I go home, my wife is going to ask me how my day went. I'll start to tell her. And if this were a trial, she would ask me, well, what did the witnesses have to say? And I would start to tell her that. And at some point along that conversation, she would look at me and she would say, well, you didn't really believe that, did you? And pretty soon I'm having a conversation about what I should and shouldn't believe with somebody who wasn't even here. You can't do that. So the way to avoid all of that is just to say, the judge said, I can't talk to you about it. I can tell you what the case is. I can tell you how long I think that it's going to go. You can ask for their help to help you avoid exposure to any media, to help you avoid exposure to anybody else's opinions regarding this case. Since they will know what it is and how long it's going to be, they'll know how important it is, and they can help you. But you have to tell them, look, I can't talk to you. I can't talk to anybody else about it. I can't even talk to any other jurors about it until you are released from further obligation in this case. That way it just puts the burden on me, because if I were to tell my wife, look, I'm just not going to talk to you about it anymore, it would lead to an entirely different conversation. So this way, this avoids all of that. Most of the eating joints you'll find are north on Tejon. There are a few south. There's a bistro in the basement, but I don't think it opens until 11 o'clock. So if we can have everyone back in the hallway, you don't have to go back to the jury assembly room when you come back. Just meet in the hallway. If I can have everyone there a little bit before 1 o'clock, we should be able to start right on time. What will happen this afternoon is that the attorneys will have, each side will have 45 minutes to ask you questions about things that they want to discuss. And then once they are done, we will select some individuals. It's actually by a process of deselection. We strike names off or excuse other people, and then we're left with some, and then we will have further instructions for those individuals. So enjoy the morning until 1 o'clock. We'll see you back then. Don't discuss the case with anyone else aside from what I've told you that you can discuss. With that, all rise for the jury, please. You can go ahead and go. Thank you. It happens. It's okay. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. With that, then we will see everybody back at 1 o'clock. Right. Thank you. Court will be in recess.
All right, guys. So 1 o'clock, they're due back their time. That's 3 p.m. Eastern Standard Time. That means he's planning to finish early because they typically don't take this break until, let's see, they usually don't take this break until later. So they're taking their lunch already. Yeah, please, guys, pray for these people who were hurt in the shooting. I'm not sure the victims. Yeah, let's talk about the Gwyneth Paltrow. I know that there's 4 victims right now. And thank you, Tammy, for bringing this to my attention. I didn't even know it was going on. I've been lost in Gannon world and I had no clue. Let me see. I'm trying to find. Oh no, they were children. This school is kindergarten through 6th grade, you guys. That's devastating. Let me see. It says 3 children are shot dead by gunmen at Nashville Christian School. Suspect opened fire before being shot dead by cops. At least 3 children have been shot dead in their private Christian elementary school. The incident took place at the Covenant School on the outskirts of the city shortly after 10 a.m. on Monday. After killing the 3 children, the gunman was shot dead by police. He has not been named. Look how small these babies are. It's unclear how many were also injured or what type of weapon was used. Parents have been told to collect their children from the school, but no other information has been given. There are around 33 staff members in the school and 260 students. Many of those students were seen running from the building today in their school uniforms after the shooting began. Other schools in the area have gone into lockdown as a precaution, but there is not thought to be any additional threat. Wow. Yeah, I don't understand it, Emily. I don't understand it. Hi, Hope. How are you? Delana, how are you? I don't even want to send my kids to school anymore. Yeah, Bub. Wow. I'm looking to see if there's like any live coverage of it, but like the Fox said that it was live coverage and they're talking about the Gwyneth Paltrow case. Like it's not. Trying to see. It was very loud. Turn that down. I had it way up. I had my speakers blasting. I'm in my office cleaning and stuff while this is going on. And I was trying my best to turn it up as loud as I could and hear anything from the jurors or the defense for that matter. It was just so quiet. Like they make it look like you can click, but you cannot. What we got here? Trying to find a little bit of information about this. For those of you who want to take a break, feel free. Get it. It's a long time period sitting and listening to court and things like that. I am gonna go over some details in Gannon's case and stuff and talk about that. Whoop, baby. Hey, let's go.
I had, no, anymore. No, it's not.
At Covenant School, a private school in Nashville. The Metro Nashville Police Department tweeted that officers engaged the shooter and that the shooter is now dead. Vanderbilt University Medical Center says 3 victims suffered gunshot wounds and were pronounced dead after arrival. The age of those victims is still not clear, but according to the school's website, it serves students pre-K through 6th grade. The FBI and ATF are now assisting the Metropolitan Nashville Police Department in their investigation. I want to bring in former chief of detectives for the NYPD, Robert Boyce, and former FBI agent and ABC News contributor, Brad Garrett, for more on this. Bob, what's your reaction to what we're learning so far? We have very limited information, but 3 students that attended this school that serve students between pre-K and 6th grade are now dead.
Yeah, there's no words for this. You know, you have a professional detachment when you look at these, when you investigate these things. But the murder of innocents, it never leaves you. It will stay with you a long, long time. I did see the quick response by the Metro Nashville Police Department in terminating this attack. But what we can see right now, anyway, now is the terrible tasking of putting these things together, putting the investigation together to find out what happened. So unusual an elementary school as it should be, but nonetheless, it's there. Also parochial school. So what's the issue here with this individual? What was going on? And that's what we're going to do in the next days and weeks and months afterwards.
And Robert, when police responded, they described this as an active shooter situation. So how do you go about responding to that kind of a scenario when there are young kids in the building? And of course, you want to be careful with that, but you want to take this person out as soon as possible.
You do. So you need immediate entry into the school and determine where that threat is and go to that threat immediately. And it's chaos, it's mayhem. I understand all those things. But the detectives or police officers responding have to go in there and address the threat immediately. They cannot wait on anything else. They can't wait for backup. So there's a degree of valor here on their response. But you have to just get past and stay in that moment and terminate that threat. That individual already put himself on a path of destruction anyway. Understand that there's other issues as well. Check his car out. Could he try to hurt more and more people afterwards? Those things have to be determined as well.
Brad, special agents from the ATF Nashville Field Office and the FBI are already responding to assist the Metropolitan Nashville Police Department here. I know you worked with the FBI in Nashville for a number of years. What goes into an investigation like this, and what resources do they have to help the local police?
Well, first of all, let's start with ATF. They're going to run any weapons that were found both at the scene and perhaps if there are any weapons in his vehicle or back at his residence. Where did they come from? So forth and so forth. Did he have them legally? But, you know, the FBI and the ATF both sort of give extra hands to the Nashville police. They are the lead. They are the ones that went, as Bob mentioned, into the building initially. They were the first responders. But if there's any secondary things that need to be done, like searches outside of Nashville, or any forensic or technical stuff that they need quickly, they've got the FBI and ATF to work them. But, you know, when these things happen, Diane, it really doesn't matter who you work for. It's all going to the goal of, let's make this as safe as possible. And that, you know, the other side of this is we don't know what was in his car. Sometimes these guys create booby traps and other things at their houses. So they're going to have to be very careful, but to have the added expertise of the FBI and ATF, I think, is always helpful.
We're looking at footage of students being escorted out of the school, walking down the street. I mean, we're talking young kids here. Brad, what do you make of the frequency with which this is happening? Mass shootings in not only in public places, but, you know, in this case, in a school full of young children.
So we're just angrier, I think, generally than we were 5 or 10 years ago. So you start with that. Okay, well, that's no justification, obviously. But the point being, if you take anger, disillusionment, isolation, and somebody that's maybe spending a lot of time on social media, you can come up with a really toxic brew. And so many of these shooters fit a version of what I just said. I'll be surprised if he doesn't. I'll also be somewhat surprised if he doesn't have some connection to this school. Maybe he attended that school, whatever it might be. But all of those things are important to figure out. But to your point, Diane, we're not on any path to stop these from happening. And unfortunately, Bob and I are going to continue to talk about them because there's no mechanism to stop them. Yes, we can sort of profile people, figure out who might be a shooter, but until you really have hard information, it's really difficult to get in front of these shooters.
So, Bob, how do you go about now assessing and hopefully confirming that this threat is over?
Well, we have a single actor here. It's more we could figure out right now, and that's what we're going forward with right at the minute. But who else was in his world could have known about this? Who else that he was speaking to on social media that was encouraging this or discouraging it? It could be either one. So you have to figure that out. It looks like a single actor right now, a bad actor that we have to identify and find out what was going on in their lives. What was the issue here that drove this person to do this horrendous, terrible tragedy? So that's what we're looking for right now. Could this have been prevented anyway? Could we have stopped him from getting that gun? You know, these things are important. You know, these all these red flag laws that are going around the country need to be followed through with, and that's the important part right here. Some kind of mental illness, I don't see why you would ever hurt a child at any point in your life. That has to be figured out.
So, Brad, where does this investigation go from here? Not only with the Metropolitan Nashville Police Department, but also with the ATF and the FBI and other federal agencies assisting.
So tying all of the pieces together, in other words, the background of the shooter. Did the shooter put anything on social media or talk to anyone about what he was going to go do? Did anybody help him? In other words, did somebody help him purchase weapons, knowing what he was about to go and do?
Sounds like they're not really identifying the school shooter yet and who was behind this. I'm not seeing an identity. Like, I'm looking on Twitter and stuff like that, you know how we do. There's a live stream of the scene itself, which thank you again, Tammy, for sending me this. Let me see here. Where'd it go? Oh, I just had it up like 2 seconds ago. So this is the live feed of the area. They're basically just clearing it. Okay, just kidding. This is commercial.
As I'm stepping.
It's tragic. It's absolutely tragic how many mass casualty events and things like that happen. The fact that this happened in a pre-K to 6th grade school is absolutely devastating. Absolutely devastating. You know, there's people on both sides of this argument, and I'm not even going to stem up the debate because there are people who say, you know, gun control and taking the guns and things like that will stop stuff like this. But I don't know. At the same time, you're in a situation where criminals don't follow laws. And so making laws surrounding the gun control doesn't necessarily help that situation, is kind of the other side of the argument. But one thing is clear, like, this has to stop. I get so sick every single time that we see stuff like this, and it's exactly, there's no justification for shooting children ever. Children. You know, there's no justification for these crimes that keep occurring, and I don't understand it. Whether it's a shooting event, whether it is these parents who are harming their children, or people who are harming children, or it doesn't make sense. It will never, ever, ever make sense to me. I just don't get it. I don't understand what has to be broken inside of your mind to think, hey, this is what I want to wake up and do today. Or even, you know, some of these people, they plan it and plan it and plan it and plan it. And And you literally, like, you spent months, like, and not just the school ones, but think about it. There was that shooter on the tram in New York not too long ago, and he had planned it for a very extended amount of period. And the top shooter, they planned it. And literally, like, your deranged mind was so focused on harming innocent people for what? Why? And like I'm not the type of person who I think everybody's life matters and things like that. And we talk about suicide and suicide prevention a lot on this channel and on Locumized channel and all of the places. But honest to goodness, if you are that deranged that you feel the need to harm someone and walk in and take innocent lives and things like that, if you are that type of person that thinks that this is acceptable or okay, or you're sitting there planning it, just take your own life. Don't do this to innocent children. This is parents who have lost their babies now because of what? We don't know if this is a child that did this or if this was an adult, but it almost seems as if they're talking about it as if this was an adult that could have been in there. I don't know. It's just very, very frustrating. Yeah, they do it for the fame or infamy. Death by cop. Who knows what makes these animals think, right? I don't know. I don't know, but it's not just them. Like I said, it's not just these active shooters and things like that. There are many other ways that people commit horrific acts. We had the stabber up here, Parkland. I think it was. Hold on, let me. Or no, sorry, Franklin Regional. He was a 16-year-old and he went in and he used kitchen knives to stab 20 students. 20 kids he stabbed with knives, with kitchen knives. And it's just they will find a way if they want to hurt or harm people. Should we make it easier? No, absolutely not. But there's something wrong with these kids. There's something wrong with our society. Yeah, it's becoming too normalized. Schools, theaters, grocery stores, concerts. Right. Leave us a note. Hey guys, I was sitting here and I was really thinking about I was going to go and harm a bunch of innocent people. So I just decided that it'd probably be best if I didn't exist in this world. We will understand. Okay. Could you have probably gotten help or something? I don't know. I really think that the people who do this, there's probably not much help for them, just to be completely honest. Same way I feel about Letecia, right? I struggle with the insanity defense. The only way that I think that health or your mental health and things like that could possibly play into a legitimate defense for murder would be if you have literally no ability within yourself to control your actions. That's the only way that I could picture it. And maybe that's just me being completely biased because I have grown up No, I'm sorry. That just doesn't work for me. And I don't know. I don't see how I don't know. To me, the insanity defense is kind of like excusing people's crimes and saying that, well, it's okay that they did this, that, and the other thing because they're a little bit crazy. Like, listen, we are all a little bit crazy, but it's not okay. Your oldest granddaughter starts preschool in the fall. You don't want her to go. I don't blame you guys for questioning if your kids are safe at school, or they're safe at anywhere. We can't live our lives in fear, but you still have to live sensibly, if that makes sense. We protect them where we can and how we can. I have the ability to homeschool, thank God. And that ability was made by the fact that my husband does what he can to get us through month to month to month to month, and we are a paycheck to paycheck family, but it's just important to me to be able to be home with my kids. and to be able to not put them in daycare and not send them to God only knows what's going to happen. Right? And so we struggle. We struggle from month to month. But we make it happen the best ways that we can. You know? And I know that not every family has that ability, and my heart breaks for the families that have to trust the system, that have to trust daycares, that have to trust the schools. And I know that financially this country gets harder and harder every day. I mean, we were literally joking around, right? Around yesterday about the prices of everything. And it's just ridiculous where we're at. Like, I made this yesterday in the Discord because, you know, In the Bushes was saying she went to the store and mayo's like $9 a jar now. Like, what happened? What happened to our economy? Why is everything so expensive? It's just frustrating. Yeah, you worry about what they will face. I don't know. It just keeps getting worse. And it's not going to improve I don't know, anytime soon. Not the economy. And so then it makes you, like I said, the parents have to go. They don't have a choice. They have to work. They have to trust the schools. They have to trust the system. They have to trust that the daycare workers that they're putting their kids with aren't going to be abusing them and doing all these things. Right? Yeah, you were crying about groceries. Exactly. But that's my point is that's why. Like, we have to have two income families because our income is so bad. It's so bad. Yeah, you're homeschooled to bless your babies. Wow, Elizabeth, that's so scary. There's an incident your son's first week of high school on Friday. Someone tipped the student was removed and did have, wow. SWAT walked into the classroom and said, "Come with us." Wow. That is so scary. That is so scary. And the mac and cheese you got $2.50 in 2 years. Your Social Security increase is almost eaten up already. Right. Oh my gosh. Yeah. People on fixed incomes. Oh, yeah. Let block no more. You worry about your grandchildren. Yeah. Okay. Everyone was okay, but school was let out early. Why? What if it wasn't tipped in? What if it wouldn't have been tipped in? That's such a terrifying thought. Like, why don't our schools have metal detectors at the front door? Why aren't our schools and our children protected like an airport would be? Lord knows you're not going to make it on a plane with a gun or any type of weapon. Why are you able to walk into a school with one? Why aren't we investing in that, in security like that? My mind was blown whenever I was seeing the shooting that happened in Texas, because ever since I was in school in 2007, I graduated, okay? And before I graduated, they had upgraded all of our security and everything else after the Columbine shootings. I would be shocked if someone would be able to make it into our school systems with any type of weapon. There was a shooting in our parking lot because there was someone who was approaching the school with a weapon, and the police were there like that and literally shot him on school grounds while we were all in our classrooms like that. That's in 2007. We're 20 what? Oh goodness, I can't math. Somebody math for me. We're like 16 years from that point. Why are there still schools out there that don't have this in place? That don't have protection in place? It's sad. It's devastating. And I mean, and we weren't in a rich community. I had like 200 kids in my graduating class, I think. Like, and that sounds like a lot, but it's really not. So, like, if that school can afford it, way back then. Why can't schools afford this? And if they can't, why isn't our government putting money and resources in to making sure that every single school in America is safe? To make sure that every single school in America has something in place to make sure that bad guys can't get in to hurt our children. I'm sorry. This is one of those topics that, like, it triggers me because we can send money to study cow farts, billions of dollars to study cow farts, or, I don't know, whatever, but we can't spend money on our schools and to protect it. Yeah, you can't see an answer unless schools become as secure as prisons. It doesn't even have to be as secure as a prison. How about just as secure as our airports? You can't walk into an airport with a nail file. You ain't getting on a plane with a nail file. But, Franklin Regional was able to have somebody walk in with kitchen knives and stab a bunch of people. It's not just about guns. It's about the fact that violent things can happen. Yeah, exactly. One person brought a potential plastic explosive in his shoe, and the whole world has to take our shoes off now. Why are we dragging our feet? How much of a hassle would it be to make your kids walk through a metal detector in the mornings to ensure their safety? We had plastic clear backpacks for the longest time. We weren't allowed to have anything but see-through backpacks to ensure that we didn't have weapons in our backpacks as we were walking in. That's a simple fix, right? We had to walk through metal detectors to go into our prom. Okay? They wouldn't allow us to take limos. They wouldn't allow us to do anything like that. We had to ride a bus. We had to go across the stage for our grand march. Before we went across that stage, we had to walk through a metal detector. Then we walked through the metal detector again as we were loaded onto buses to take us to the prom location. Once we got off of that bus, guess what we did while we were walking into the restaurant where we had our prom at? We walked through metal detectors a third time. We're talking 2007. So if they knew it was this much of an issue way back then, why aren't we doing this everywhere now still? Metal detectors are already a joke to high schoolers and ineffective. You never had to deal with any of this. True crime with Shannon. You went to school when Columbine happened. Yeah, I graduated in 2000. They were just starting to implement stuff. Right? People are gunned down everywhere, all ages. I agree. It's a society issue. It really is. Our country needs God whenever it comes right down to it. Like I said, this applies to everything. Whenever you think about the sick, deranged person who would have walked in there and done this, the person who planned out this event and carried it out and killed 3 children between preschool and 6th grade. So we were talking, what, 4 years old, 5 years old to 11, 12? Yeah, your school's locked down. You can't even get in the front door. They can put a camera and you have to ring a bell. State your business exactly. All the things. We have double door system too, where you go in the one set, you can only get to the office. You can't get anywhere else but the office. You cannot walk inside of the school, period. period. It's just that simple. You can come in through that front door once you get buzzed in or whatever, but you cannot go into the school, period. Yeah, too much anger and ignore mental illness. You see it here in the UK too, just not with guns, but the behavior is the same. Exactly. And that's just it. Like, there's just so much anger and violence and it's everywhere. And that's what I was saying. Like, this doesn't just apply to schools. This doesn't just apply to mass casualty events. This also applies to, why are parents killing their kids every day? Why are we seeing so many events like that? Why are we seeing so many child victims? So many victims, period. Domestic violence and things like that. It's just sad. It's just sad. Sorry, guys. I didn't mean to get off on a thing, but I did want to look at that because it was brought up and see what they had to say, see what's going on. It's just really pray for these families. Let me find, so we were almost completely through the arrest affidavit. We were on the last 2 pages, I think. And then I want to start looking at her letters to the judge. Yeah, it's going to take a multidisciplinary approach to solve this and people to think with their hearts, right? Yeah, the children are the future of every country. It's devastating when these future Einsteins don't have a chance. Graduated in 88. I wasn't even born until that next year. I was born in 89. All right. So I believe we were at the last paragraph or so of the conclusion, but I'm just going to start at the beginning of the conclusion because it doesn't make sense to pick up at the very last paragraph. So it says, in conclusion, based on the data collected by the FBI and reported in the Journal of Forensic Sciences, I learned that in over 71% of homicide cases that involve false reporting, the reporting party is responsible for the murder. To be clear, the statistic is not being provided as sole probable cause for the requested warrant, but as an additional fact to be combined with others listed in this affidavit. Based on Letecia's internet history, I'm so sorry if you can hear them singing. They're singing with Coco Melon. Based on Letecia's internet history, it is reasonable to believe that she was unhappily married to Mr. Stauch and had some degree of resentment towards the family as a step-parent. Furthermore, the days before Gannon's murder, Letecia appeared to be researching a move to another state to a 2-bedroom apartment. She has not provided a full, truthful statement to investigators at any point during this investigation, particularly regarding the circumstances of Gannon's disappearance. This would reasonably be suspected activity of an individual that committed the crime under investigation, namely murder. Within approximately 24 hours of Gannon being reported missing and without external prompt, Letecia made claims to law enforcement that she was being set up. Initially, Letecia and Gannon said Gannon was playing with a neighborhood friend between approximately 3:15 p.m. and 4 p.m. and was expected home at 6 p.m. Within a few days, Letecia changed her story to label herself as a victim of rape, felony menacing with a weapon, assault resulting in Gannon's abduction by her rapist. Her stories continue to evolve to include new locations of Gannon's disappearance over 30 miles away, several completely different set of circumstances, and unprompted explanations for why Gannon's blood would be found by investigators in key locations. Letecia was unable to provide a logical reason why she rented another vehicle while she still had access to the Tiguan. Based on the aforementioned facts, it was likely because it contained the remains of or evidence of Gannon's remains based on positive reactions to luminol on the Tiguan bumper, indicating the likely presence of blood on the rear tailgate. A suspected blood sample from the interior of the trunk area returned a negative result for presumptive presence of blood. Gannon's mattress has a large red stain on it that is consistent with blood. Based on the orientation of the mattress in the room, it appears that is where Gannon's head and upper torso would have been. Sorry about that. Okay, so Gannon's head and upper torso would have been. Below that same area, a substance that was confirmed as blood by the Metro Crime Laboratory soaked through the carpet, the pad, and stained the carpet or the concrete. This blood matches the DNA profile for Gannon Stauch. In the same area, blood samples taken from the wall, namely an electrical outlet, were also confirmed to match Gannon's DNA profile. Gannon's blood, again matched to his DNA profile, was also found in a piece of particle board in the area of Highway 105 South Perry Park Road in Douglas County, Colorado. This particular area is consistent with Letecia's travels on January 28th and January 31st based on a GPS tracker, locations of her Nissan Altima rental vehicle, and raw data from the Tiguan. During her stories to Mr. Stauch without prompt, Letecia provided explanations for why blood would be found on Gannon's bedroom wall. Other than Letecia being present for Gannon's murder and being present for the cleaning of the murder scene, there is no reasonable explanation for how Letecia would know there was blood on Gannon's wall, as that evidence had not been released to the media. They knew this very early on, and they didn't tell us nothing. They didn't even tell us that he had been suspected to be dead until mid-February.
Are you okay?
Okay.
All right,
Okay, so sorry, they're bickering over a toy, so I'm like looking and trying to calm them down a little bit. Let me see. I've totally lost my place. Hold on, where am I at? Okay. That information about the blood didn't ever get released to the media. And so mid-February was the first time that we ever heard that they even suspected Gannon was deceased. The way that they were searching for him, we always thought that there could have been a possibility that he was out there somewhere. Until the details started coming out from her about the blood, about the particle board, and things like that. But the investigators never said it out loud. They never said it out loud. Yeah, no matter how many times I read it, I know. It's devastating. Again, without prompt, Letecia provided an alibi for why she was in the area where the particle board was recovered. By combining cell tower data, reviewing video surveillance, and home security system logs, investigators believe, on the evidence, the only 3 individuals with access to Gannon in the afternoon of January 27th were Letecia, Harley, and 8-year-old Lena. I don't know, Bob Smith. I don't know why people think they can get away with killing someone. I mean, I know that there's a lot of unsolved cases, but to be completely honest, so many of those even are getting solved now. I mean, there is a ton that with DNA evidence and the way that the car GPSs and phones and everything else like that, there is a ton of stuff that just you don't stand a chance. You know, they will find something on you eventually. You may get away with it for 1 year, 3 years, 5 years, 10, 20 years, but they will eventually get you. They will eventually find out what happened. So, with the exception of Lena, who is not considered a suspect, it appears that nobody other than Letecia was with Gannon at the Stauch residence between the hours of 2:16 and 5:34 p.m. on January 27th, 2020, when investigators suspect Letecia murdered Gannon. So remember, she would have murdered him. They actually went into the house around 2:21. They're estimating the whole crime took place within the first 15 to 20 minutes. And so that would have gave her 2.5 hours before anyone else was in the house to be able to try to start cleaning up this mess. And I'm sure once Harley got home with the rest of the supplies, that she probably continued to clean. So Gannon had been missing for approximately 4 weeks, and there has been a national news attention on major networks related to his disappearance. Local efforts, including posters, news coverage, search teams, and social media postings, have also failed to locate Gannon. Aerial arrest, infrared FLIR technology, and other extraordinary methods have been deployed to help locate Gannon. Over 200 volunteers have helped to search for Gannon, comprising of thousands of man-hours in several different locations. Additionally, although EPSO has received hundreds of tips, nobody has provided information that has led to Gannon's location. His family and friends have not heard from him, and Gannon is only 11 years old with no financial resources. Letecia was the last person to see Gannon alive. Investigators have not located Gannon's remains at this point in time, although the search continues. As additional time increases without locating Gannon, it is more likely that Gannon is not alive. Based on the facts set forth, I submit probable cause exists to believe that on or about January 27th, 2020, within the state of Colorado and within El Paso County, Letecia committed the offense in violation of the Colorado revised statutes to include murder in the first degree, child under 12, position of trust, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. Therefore, I respectfully request the issuance of an arrest warrant charging the same. And so that was on the 28th of February. Letecia was arrested on March the 2nd, and Gannon was found on March 17th. Yeah, lots of crooks shaking in their boots over DNA. I believe it. They did. They did an amazing job holding things close to the vest. There's a case here where they know who did it, but they are waiting on new DNA technology to test the evidence to be absolutely sure. Hi, Vanessa again. Yeah, I know. It's so sad about work. I am too. But honestly, Emily, they don't have any reason to have had to offer Harley a deal at all. Like they have so much evidence that they don't need Harley's testimony against her mother. And so I fully believe that if Harley was involved in any way, shape, or form, that they would have given her some type of charges. She was close enough to 18 that they could have tried her as an adult and just been done with it, right? In the bushes. You're such a grifter. You're such a grifter in the bushes. We do pay for a lot of documents. Letitia's have all been free though, thankfully. The Colorado has been amazing about keeping all of her documents for her into a nice, neat little folder on their website because it was such a high profile case. And I absolutely love them for that because it just makes it so much easier to find everything. Let me show you guys how they do this. Whenever you go to Colorado's website, they have this nice tidy little case file here where they have their cases of interest. And so anything that is like popular going on in Colorado, they just have it right so you can just click on it. And so since Letitia's case has had so many filings and so much going on, they have 3 different little spots where you can click in and see. And so they have the initial stuff from 3/12/20 through 12/27/21, and then from 21 through 23 and 23 through present. So that's where we can see all of the different things that happen. For example, this is where you get the filing about being able to have, for example, expanded media coverage, or her motions to not be able to come to court are under here. Her letters to the judge and any other letters that she may have sent are all under this. So I love Colorado for doing that. I wish more states would do that for cases, especially what they deal what would they deal with. Harley, she quote unquote went on vacation, but really it was just a trip to go see her boyfriend. Her boyfriend doesn't live like right here. And so, and to be completely honest, I think everyone who had to come to court to watch this and and I think that everyone who came to court or has to be part of this should get to go on like a vacation before and after, to be completely honest. I wish that like Gannon's mom and dad and his grandma and his aunts, I wish they would have all taken like a brief thing to clear their head so that they weren't stressed walking into the courtroom. And I wish that we could send them all on a nice little trip after it was over so that they could clear their head again because they're going to see horrific things in this courtroom. They're going to see awful, awful, awful things. The Spudler, thank you so much for your donation. Thank you. Super sticker. Oh, yeah. In the bushes got her griff game going. Thank you, thank you. Yeah, thank you. Yeah, I can't imagine how they're feeling. Honestly, and then a lot of people forget this, but Gannon had a stepsister as well, like through Landon's marriage to Mike, that he was pretty close with. There was actually a bunch of different videos on YouTube of him playing with his sisters. And the baby too, the youngest, they just don't I know they don't understand where their brother, where she doesn't understand where her brother is. She probably doesn't even remember her brother that much. Emily Flotilla. Thank you so much, Emily. You guys are so awesome. Thank you, thank you, thank you. Let me pull up these letters. Goodness me, where is it? There's so many things. Okay, so this one is from August the 12th of 20. Yeah, super sleuth mom. Yeah. Sorry, that was a weird one. Thank you. I was like, aw, you, Emily. Yeah, aw. Okay, so this one was from her to Judge Gregory Warner. Think this is the first one. I'm trying to double check. I'm looking through, but I'm pretty sure this is the first one. Now, again, we're looking at this with a DID diagnosis. And so whenever we hear DID diagnosis, we're expecting to see her be a completely different person than what we know her to be. And to have no knowledge of what happened during the crime, right? Because she was a different person during the crime. Thank you, Andrea. Okay. Yeah, this looks like it's the first one. But okay, so in this time period, she had been arrested. She was trying to get to go to court from home. Like she wanted to work on her defense from her home was one of the things that she had filed so that she could be let out to properly work on everything. That, of course, was denied. She requested to, let me see. I want to say that there was the competency eval. Yeah. Judge's order for competency evaluation was in June. And then from the June competency evaluation, she started basically subpoenaing the judge and writing letters to the judge about her counsel. You know, she did not agree with her counsel. And what's wrong, baby? Do you want to say hi to everyone?
She has.
I don't think so, the Spudler. As far as I know, DID, like you have no clue what the other side of your personality did, right? Your original personality is completely blacked out to everything that goes on while you are your alternate person, or at least that's my understanding of it. But I am no psychologist. I'm just so I don't understand how any of that would make sense, right? Any of it. Hi, Betty. How are you? Okay, so let me just read this letter. It says, "Good afternoon, sir. I thank you for taking the time out to read my letter and my concerns about an unfair process that is going on in my case. I have expressed these concerns several times to my defense team, and I feel that I have not been afforded my rights as a United States citizen. It has been 5 months, and I have met with my defense team one time in March of 2020. It's the middle of August. I understand this pandemic is unforeseen, but I don't feel I should be held unconstitutionally." Again, with her constitutional rights, guys, she always brings that up. So she feels she's being held unconstitutionally, denied access to her attorneys, and have constitutional rights violated and be abused in the process. First, as you know, there is over 30,000 and growing pages of discovery in my case. I cannot successfully participate in my defense on a phone call 3 times a week, 1 hour at the jail. I have no way to view any videos, read any reports, review phone data, etc. I am not an active participant in my case. I know that the jail is listening to my attorney-client calls, as on several occasions I commented about someone or something specific, and the jail immediately acted upon it, aka her attempted escape plan. I'm guessing, because, she got busted on that very quickly. Officers also wait outside the door, easy to hear, and sometimes a video camera is on me at the TV near the phone. Sir, these things are a violation of my rights. In addition, I have no way to write these things down as I'm always restrained, with more times than not causing injury. I understand you cannot tell the jail how to run their facility, but I know that I can't ignore my rights being violated. Next, sir, I understand the Eighth Amendment protects cruel and unusual punishment, and I know the Supreme Court says punishment can be just for the crimes. However, I'm in a county jail and I'm presumed innocent. Not to mention, I am innocent, and we will prove it. I have been a pillar in my community in South Carolina, and I have no adult record, never done drugs, and have a doctorate in education. I've proven myself as a responsible citizen and should not be subjected to cruel punishment that I received at CJC. Sorry. Somebody just messaged me on Discord. I want to reach over and check it real quick. Over 15 plus times, I have been abused in transport, ranging from injured ribs, a knot on my head, several ankle and wrist bleeding, bruises on my knee in my cell, loss of feeling in my hands several times. I've had to be on insure 2 weeks due to the poison comments, and just recently on 8/11/2020, I received threats in my peanut butter because I provided evidence of not only my innocence, but evidence that will show who it was through my PI. That's right, folks. She is receiving threats in her peanut butter. She literally sent this to the judge. And so whenever we look at why Gregory Warner has sat here and let her do motion after motion after motion and given the defense like all of these delays and different things like that, he knows that she is going to try anything she can to file an appeal. Absolutely anything she can. No. So she had a public defender. She had the public defender's office initially. Then she opted to represent herself. And when she decided that she now needed a lawyer again, she filed, there was a conflict with the public defender's office. And so they were able to opt out and remove themselves, and she got an actual private attorney, which is Tolini. Yeah, because she's a Karen and no one likes her. I just want to know, like, that was something that we all joked about for a long time, was like, how exactly are they putting threats in her peanut butter? Like, are they drawing pictures on her sandwiches, or what exactly is happening? So as a result of this, I assume their runners use people in trusted positions in jail to send me threats in my food, and I'm terrified what will happen next. I don't know how I'm supposed to properly defend myself if going through this unfair punishment, being denied my constitutional rights, here we go again, being denied access to my attorneys, being under scrutiny, causing daily mental disturbances, being restrained, causing injuries, being denied law library access, etc. This is not okay in a country in which our country prides itself on democracy, a country with a flag that got a hole in it at Flanders Field in World War I. One that turned blood red in World War II, or one that got cut with a sword at Chancellorsville. I think that's what that says. Through all of this, the flag stood. We raise her up every morning because this country still stands for freedom, perseverance, justice, and vigilance. And I know what Congress decided on June, I think that says 14th of 17. Is that a 9 or a 7? I don't, 1797 maybe, or 1777 Flag Day, that it still rings true that not even to the evil terrorist of 9/11 can take the American spirit away. However, I'm showing the same things that flag shows: valor, courage, purity, and innocence. To write you to say, I do not feel like a U.S. citizen being treated this way in my beloved country. I'm not getting fair process. I'm not getting represented properly. And I'll give the benefit of the doubt of a pandemic, but the other unjust treatment is not the way that our founding fathers intended this process to go. Not to mention no pandemic, no terrorist attack, no police riots, etc. can stop our country from being the greatest on earth, upholding the law and staying true to following one's constitutional rights. What's that, the fourth time she said that? This is just the surface of my concerns. As you will see, they only get worse with illegal search and seizure. I was a victim of cohesion. I'm not sure what that word is supposed to be, as it's mental and physical. Sir, you can tell I'm educated. I know Miranda versus Arizona, etc. However, a person cannot perform under this scrutiny, abuse, coercion, etc. And that's what has happened throughout this entire process. Besides, due to info from my PI, I don't even feel that El Paso has jurisdiction, not to mention the wrong individual. I reach out to you to let you know that I'm very concerned with this process because I know that you will uphold the integrity of the court. And he has thus far continued to uphold the integrity of the court. Oh, yeah, Michael Allen is gonna hammer at her letter saying she was sane. She is not insane at the time of what she did again, and I guarantee it. Yeah, she's Joan of Arc. She really is. She really is. She is such a great symbol of American greatness. Right. Right. Do we have any flags? Let me see. No, no American flag emojis. Man, she could have been representing. Yeah, she's so stupid it makes me laugh. I know, Dawn. She showed the world how smart she was with that news interview saying Gannon will be found alive. Well, she stuck her foot in her own mouth with that statement, right? Oh my.
Mommy, I need some cream on my foot.
What happened to your foot, baby?
I just need a little.
Do you want to say hi to everybody while you're standing there? Did you drop something on it, baby?
No,
Did you step on something?
no.
Okay. So go ahead, say hi.
Hi. I got a boo boo on my foot,
She's got a hurt foot. Sorry.
and I need some cream on it.
Yeah. We'll get you some cream. Tell them have a good day.
Have a good day.
Dawn, we're going to be streaming it. It's going to be through WebEx cameras. So there's going to be 3 views of the court, one on the judge, one on the witness stand, and one on the courtroom itself. Just making sure that the the jury is not filmed is what they're trying to do. But we will be streaming it. It won't be on TV itself, just on WebEx, but they did give us special permission to restream for this one. The children's voices are heart melting. I don't know what she stepped on. I think she stepped on something, but Big Brother is helping her out. So, Seal, I would never replace you. Seal is my personal PI. So, okay. So, where was I at? The integrity of the court. Okay, so the judicial system that I know does not allow a person who is presumed innocent and who is to improperly defend themselves to be subjected to daily abuse and Eighth Amendment violations, does not deny Fifth and Sixth Amendments and or speedy trial and fair trials. Yes. Yeah, Dawn. Great. I know, right? I'm so glad that they're letting it be restreamed because Ord and Orson West, their trial starts tomorrow, Classic and Sincere. 9 a.m. is their opening statements, California time, which is noon here. And they're not allowing it to be restreamed. They're not allowing it to be recorded, nothing. So there's just going to be a reporter in the room who is going to update us at the end of each day, News 17. So it's kind of frustrating that they're doing it that way. But that trial is supposed to be allowed to, I'm sorry, they're going to be taking them on, Presser is on for Nashville victims. Okay, I'll pull that up. They're taking that trial on a road trip. So let me pull up at Presser because I do want to see that.
Is everybody got sound mic'd up? Everybody good? Waiting here and waiting here.
We're good.
You're good here. No, over here. Good. At 3 o'clock this morning, arrest warrants charging aggravated assault and aggravated robbery were issued against Lamont Witherspoon in connection with a robbery on January 24th at Nashville Pizza and Pasta at 1201 Dickerson Pike. In that case, the suspect went into the business after the employee had just returned from a delivery. He was holding his arm behind his back, demanding money. He wound up walking out with the cash register. And as the video later showed, the object that he was holding, which he implicated to be a gun, was actually a cell phone. But nevertheless, this was a aggravated robbery because the owner or the employee of the business thought that the suspect was armed with a gun. Through investigation by Detective Kiera Ward, who has been on this case for days and has been working pretty much around the clock, Lamont Witherspoon, age 30, was identified as the suspect. Witherspoon was learned to be driving a stolen car. We were able to learn that the car lot from which the vehicle was bought actually.
I don't think this is it. Is this it? Happening now. Did he steal a car and stuff? No, this is from January. This is old. This is not it. Hold on. Let me find the right one. Yeah, you did. You definitely sent me the wrong thing. Hold on. I will find it though. Let me find it. Okay, wait. Sorry, I'm just looking to find it. It's a female teen was who did this. Ugh, that's devastating. I'm looking for like an actual press conference, but I don't see an actual press conference. Hmm. That is devastating. Three children and three staff members. The shooter was killed on the second floor. A spokesperson said she had 2 assault-type rifles and a handgun. It was a girl, a female who appeared to be in her teens. They engaged the attacker, who was described by police in the afternoon news conference as a female who appeared to be in her teens. They first got the call at 10:13. They first responded Wow, wow, wow. I can't believe it was a girl. That hardly, it's not very often that you see a shooter that's female. Special breaking report. Okay. No, you're fine. It does say that there's there, but I'm like looking for an actual recording of it. So give me just a second. Wow, wow, wow. There's a lot of live feeds, but I can't find anything that I can like rewind on. So far. That's devastating. I don't know. I don't know. You have the link, Dawn? You want to drop the link? I'll give you a link to come up and you can just drop it in the back chat for me. That would be great. Yeah, you've never saw a girl shooter. Check your messages. Okay. Thank you. Thank you. Sorry, I haven't signed on to Facebook in forever today. Been running from my Sleuth Mom account. Okay. Thank you so much, BC.
Later in the morning with Chief John Drake and others. At 10:13 this morning, the police department received a call of an active shooter inside Covenant School, Covenant Presbyterian Church. The police department response was swift. Officers entered the first story of the school, began clearing it. They heard shots coming from the second level. They immediately went to the gunfire. When the officers got to the second level, they saw a shooter, a female, who was firing. The officers engaged her. She was fatally shot by responding police officers. There was a 5-member team who was on the second floor at that time. 2 individuals from that 5-member team opened fire on the shooter. We know at this point that this shooter is a female. She appears to be in her teens, although her identification has not been confirmed at this juncture. We know that she was armed with at least 2 assault-type rifles and a handgun. We are efforting now to identify her. She entered the school through a side entrance and traversed her way from the first floor to the second floor, firing multiple shots. We now know that there are 3 students who were fatally wounded, as well as 3 adults inside the school. We are working to identify those victims. Including the shooter, a total of 7 persons were killed as a result of this morning's incident at the school. By 10:27, the shooter was deceased. The officers had engaged the shooter by 10:27, and she was deceased. Again, I said the first call came in at 10:13 this morning. We'll have more details to give you later in the morning. Chief Drake will be here in a bit. Now, Kendra Maloney from Nashville Fire.
Fire department crews are dispatched for active shooter incidents as well, for medical support, but also for an RTF response, which is a rescue task force response to go in alongside of MNPD response. Our crews were right there on the scene to provide medical aid to any survivors, but also be there for victims so that we could try life-saving efforts in this case. So we went in as soon as it was safe for our responders to do so, to try to provide life-saving efforts for those that were impacted by this incident and this tragedy. Our crews were able to be on scene to pull out those that had viable signs of life, those that were still showing the option to be saved. And we did make transport of 3 individuals and 3 children, and then 2 adults that were taken from the scene. Our crews then set up a reunification unit. That reunification unit is at 2100 Woodmont Boulevard. That's where parents can go to be reunited with their children. All of the remaining students were able to be escorted out of the building with faculty and staff. We're not sure about the processes that they had in place, but we were on scene to help them mitigate anyone from seeing exactly what else was going on, but we're sure that they heard the chaos that was surrounding this. So we do have mental health specialists and professionals that are at that reunification site for both the students and the families that are going to be affected by this today. Our OEM units were able to provide buses to make transport from the Covenant School to the reunification site. We had one bus that carried 74 students and faculty staff members to the reunification site, and an additional bus that had 34 students on them. So all of those persons were carried. It was difficult for us to kind of identify who was just there as part of staff for the church versus who was there for the school, because it's all housed in one building. But at this time, we were able to get that number of persons transported out of the building and into that reunification site. So that is where parents can go to be reunited with their students. There is a hotline being set up for parents to call, but right now that is where they should go, 2100 Woodmont Boulevard, which is Woodmont Baptist Church. Additionally, we do have a debriefing site set up for on-staff or personnel who are working this incident, and there are mental health professionals set up there for them as well. There was one police officer that was injured with a hand injury as a result of making an attack on this incident. But other than that, there have been no additional injuries to first responders or personnel responding to this. And as Don mentioned earlier, we will have further updates coming later on in the afternoon.
So on a typical day, there would be about 209 students inside the school and approximately 40 to 50 staff members, about 42 staff members. I'll take just a couple of questions before we go back.
So the 7 dead, and then the nature of injuries, how many injuries do you know that you're being treated still, or injuries? I know first responders were.
An officer had a wound from cut glass. That is the only other injury that I'm aware of. The 3 students are deceased. The 3 students who were shot are deceased. 3 staff members who were shot are deceased. That's a total of 6 victims. And then you have the shooter who was engaged by 2 of our police officers, part of a 5-member team, and she is deceased for a total of 7 individuals. There are no other gunshot victims, non-lethal, that I'm aware of at present.
Do you know how many people were shot? Do you know how many people were shot before the police engaged the shooter?
No.
Do you know if they shot anyone after they engaged the shooter? Do you know if the shooter was able to shoot anyone else?
What? We do not know who she is at this juncture. We're trying to identify her. She does appear to be in her teens. Again, with 2 assault-type rifles and at least 1 pistol. No, I'm not.
Was there an SRO or an SSO working at the school?
No, this is a church that operates a private school. There was no Metro Police personnel assigned to that building at any time. You said 2? No, there are a total of 3 adults 3 adults who have been fatally wounded. No. So let me go over this again. You have a total of 6 victims, 3 students who are deceased, and 3 adult staff members from the school who are deceased. The shooter herself makes 7. I do not. There is video from the school that we are viewing now to try to learn exactly how all of this happened.
Can you say where the victims were located? Were they in the hallway, in a classroom?
I cannot at this juncture, as you know, 5 of the 6 were transported. So we will get that information later in the day. It is an upper level part of the school. It's kind of a lobby type area. It was not in a classroom per se. All right, we'll be back shortly with more detail. We'll tweet out, give you a 15-minute or so notice before the next one, okay? Thanks.
Aren't you guys tired of covering this? Aren't you guys tired of being here and having to cover all of these mass shootings? I'm from Highland Park. Family vacation with my son, visiting my sister-in-law. I have been lobbying in DC.
Yeah, we're not gonna let that lady wants to turn this political and stuff like that. We don't need that. We don't need that. There needs to be changes. There needs to be stuff, but I hate it whenever I watch people take these events and these horrible tragedies and the moments that the community and the parents and everyone is suffering to stand up on their political agendas. That's not what's needed today. Prayers, right? Prayers for these children, prayers for these families that are grieving, and then let's take a step back and look at what we could change. They should have already been taking steps back and looking at what we could change for all these years, but grandstanding right then and there on live cameras after a tragic press conference is not the right time to be standing there pushing your political agenda. It's just not. It's just not. Yeah, it's for later, not right now. Exactly. Have a good day, Dawn. I will listen for the next update, or BC, anyone, if you guys are keeping an eye out on that, if you could let me know when the next update is, providing that it's not after the court goes back live, I will play the next update as well. And I'm sorry, guys, I know it's triggering to watch this, right? True crime in itself is extremely triggering. And if you are having a difficult time with anything that's going on, please, please always take care of yourself first, right? You can always come back. We will always be here. You know that we will be here probably another 3 hours or so. You're welcome back. But I was glad that Emily left if it was triggering her, and anyone else who may have left because it's triggering. But at the same time, I also know that there are people who may have family or friends or children in that area that the coverage needs to be out there at the same time. So I don't know. It's devastating. She was 27, Dawn, so she wasn't a teenager. I wonder if she went to their church, because I said it was a church school. If she graduated from there, if she had an issue with someone inside of the building. But again, how do you justify killing children, going after random people doing this event? If it doesn't make sense. It just doesn't. Wow. Yeah. Wow. Wow, wow, wow. Sorry. That's in Nashville, Tennessee. It was a shooting that took place at a private Christian school in Nashville, Tennessee, and it's called the Covenant Presbyterian Church. They have an enrollment between 195 to 210 students. So, I don't know. We'll keep an eye on it. There has to be some type of connection, I think, the Spudler. I mean, unless you're just randomly targeting, it wouldn't be the first time that we have seen shootings take place in religious buildings simply because of the religious affiliation and things like that. So, just confirmed 28 years old. Okay. Thank you so much. All right, I am going to go back to this letter because I do want to try to get back to or get it through it before the judge comes back. You want a pink one? Let me see. Yeah, they teach preschool through 6th grade, right? Okay, so where was I at? Oh my gosh, sorry. Okay, so she talks about the 8th Amendment violations and how they don't deny 5th or 6th Amendment speedy fair trials and doesn't interfere with attorney-client privilege. Yes, I can tell you many situations in which I know they are listening. I can tell you many situations that I know that they are listening. It does not physically, mentally, and emotionally abuse innocent people waiting on trial. Does not allow that individual to be in danger, not just from the inmates, but from employees also. And also does not avoid these situations, causing an individual mental health to decline and safely be at risk. I live each day not knowing what will happen to me, what person will be put in, what person will put something else in my food, what rights I'll be denied tomorrow, or what injuries will occur next. Sorry, my brain's just like, whew, just a lot of sad. Like it devastates me that happened. Um, Okay. I support law enforcement. I support our military, our country, and I know that a few bad apples incidents can ruin it for good people. I extend my concerns to you as a first step in this because my attorneys have refused to let you know due to public knowing. My life is on the line. I'm innocent and I'm ready to return home and use the degree, sorry, EDD that I worked and cannot do. Wait, okay. I was like, where am I missing something? The page went over further and I had it's covered with my chat screen. That I worked diligently for and cannot do that if I'm afforded those rights if I'm fighting for my life daily. I'm clearly no threat to myself, etc. Again, this is just the surface of my concerns and ask that something be done so that I can get this behind me. More past this trial in life. Forgive those who persecuted and afflicted me. Continue to be a soldier for Christ and repair my mental state. And most importantly, grieve. Grieve what exactly? Because she is, I guess at this point they knew that Gannon was deceased. So, because this is in August. I need those constitutional rights in order to be successful and participate in this process. I'm a prisoner, bound in chains, like Paul said, but I know my Bible's not bound. I also know he appointed people in authority to respect them because they are chosen to uphold the law. Please accept this letter of letting you know, first, not going over the court's head and following the approach of chain and command. Something has to be done, sir. Thank you. God bless, Dr. Letecia Stauch. P.S. If there's any possible way to receive acknowledgement of your receipt of this letter, so I know you are aware. And he does acknowledge it. He brings it up during the court hearing, the next one. Sorry, but I am open to being convinced she was mentally unwell because that is fair, but she did this horrible thing. She is a horrible person. These letters show mentally stable to me. Right. And she actually talked about her declining mental health. If her mental health was declining throughout this process, that doesn't mean that she was declined when it happened. That means that it's declining, right? You've been watching the skiing accident trial. It's okay, Rexy. Lots of stuff. Lots of stuff going on right now. There are so many trials. Yeah, Dr. Letecia Stauch will never not be a knee slapper. I know. Yeah, your eyes are rolling out again. Her writing skills do not reflect a doctorate degree in education. Yeah. Part of that could be my reading skills, but it also could be her actual doctorate skills. Let me sign back into the court just to make sure that they're not back already. Sometimes they sneak in early and turn it on at least. That way, whenever they start talking, we are there already and I can hear it now. Okay, it's not back open yet. Just wanted to double check. So that was the first letter. After that point, let's see. So after that point, her evaluation for competency came back that she was competent to stand trial. The defense then, of course, requested a second competency evaluation, and she was found competent again, right? Let's see. I want to see when exactly she requested to represent herself. I want to see that. Okay, so then sometime before November or March 12th is when the defense motioned to withdraw. And it was her public defender's office motioning to withdraw because she had elected to proceed pro se. And so that's the date that she decided, we are done. It's okay. You wish they had a giant eye roll. Yeah, I love the trials because you get to hear all the facts. Exactly. There's so many. I wish there wasn't so many going on simultaneously. That's my issue. So it was dated February 26th, but it was filed with the courts. It's on their record on March the 12th. So once she started representing herself pro se, she was assigned Tolini, which is her current lawyer, to oversee the acts and things like that and what she's doing and to assist her in her if she had any questions and things like that so that she could help with the court process. And she goes down to the law library. She gets just the disc, I believe, or it was a thumb drive of the evidence and a pile of papers. Goes down to the law library. My guess is she's seen all the evidence, seen all of the video footage, pictures, things like that they had given to her. And after that, she started refusing to go to the law library. I think at that point, she knew she was screwed. They had too much evidence against her, and she did not know how to proceed at that point. Even though she kept telling us that, of course, she had an ace in the hole. So they also had more letters. Let me get you this next one. Yeah. Oh, yeah. She at one point went pro se. I think so too, Amelia. I think it was just a trick to be able to see what exactly they had on her. Yep. She wanted to see if they had a specific piece of evidence, is my guess. I think she was looking for one thing. She wanted to know one thing. And once she's seen everything, I think at that point she was just done. She just knew that she was done. So notice this one, again, completely different handwriting, right? And this is something that the DID doctor is going to be talking about. I can guarantee it. So this was the original letter that we pulled up. Let me see if I can pull up the letters to Kit Kat and stuff. I think I still have them in my thing saved. And I know that the DID doctor is going to talk about this because this is what she mentions in her videos about DID. This is some of the things that they look at, is the difference in handwriting. So this one is different. This one is different, right? All these different handwritings that she had sent to the YouTubers. Oops. And then now we have this next letter to the judge, which is this one. And again, it's different handwriting. So this one says conflict hearing info. This was dated on February 21st of 21. It says on 2/19/2021, I was unable to talk with the Judge Bain about my conflicts with my defense team due to one, the actual privacy of the booth and the transport over. She had to prove why she had a conflict with the defender's office for why they couldn't come and represent her anymore before she got approved a private counsel, which, like I said, was Delaney. So she had to go see a separate judge than Judge Warner because of the fact that, that way it could prove that it was an unbiased decision. So she had to go talk to Judge Bain, just to give you a preface before this letter. So the actual privacy of the booth and the transport over, I explained in detail to him, expressing my concerns of privacy. I had very difficult morning mentally because I am not mentally well. One of the main issues with my attorneys is their lack of ability to gather evidence. Why can't they find Guardo? Why can't they find all of the evidence that she is innocent whenever in her mind it all exists out there? And so she's blaming this on her defense team for being incompetent because they can't find her made up stories. And it's just ridiculous. Yeah, your handwriting changes depending on how quickly I write, right? If I'm in that mood, etc. Does that mean you have DID? It's possible. I mean, only if you kill someone, allegedly. So due to this, I find very little value in the term expert, quote unquote. First, they were unable to obtain my mental health records from Charleston, South Carolina. When I finally paid a firm in South Carolina to obtain them, in 2016, I was diagnosed with blank and received treatment before work for over 28 hours of care. The school district even provided extra services and later let me medically resign due to ongoing reality breaks. What was she diagnosed with? What are we going to see in these documents from 2016 that are causing her to have ongoing reality breaks? In 2018, I was hospitalized in Canada, crossing the border for 2 days, and completed more OP treatment when I returned. I can tell you this because it sets the stage for why I cannot work with my attorneys. I signed release forms for them to get all of this information so they would have a better understanding of why I'm all over the place some days. I asked them to use the info from a non-biased doctor who worked with me more than 2 hours, but instead they sent a lady who was clearly an actress and friends with the DA. She spoke about him in an unprofessional manner, their history and his election, and now I'm sure all of this was true. But I thought she worked for the court, not one particular side. My attorneys did this to make me look like a perjurous individual. Instead, it was malfeasances, I don't know, on their part. I have included several reasons to support my claim, as I have kept a timeline with these conflicts. Communication is broken beyond repair. I explained these issues to Judge Bain, including the lack of access and visitations in complete detail. Inconsiderate of evidence. Since March of 2020, I asked my attorneys to preserve the GameStop footage, to locate the Texas police officer whom I spoke with, and to get the cruise passenger list. Instead, they spent months contacting my family for mitigation when I asked certain things. They kept saying they will let the investigators know. 1 year later, same answer. My evidence. I haven't physically seen any while being held at CJC for 1 year. Yes, COVID, but inmates were still being held as our constitutional rights were adjusted. Overlooking statute and evidence. They overlooked the competency statute about video recording. Human error? ? Okay, but this happens often with evidence in which me and the non-expert has to provide corrections to the evidence. Sharing info. They were texting my family and giving them info that they should not have, causing several disputes. My judge. They filed the motion knowing this county would not grant me new attorneys, to sabotage my chances of a trial by judge. They knew I wanted to present evidence to him without exposing any new info on my son's father. The son that doesn't exist, by the way. On my son's father. However, they created incorrect conflicts instead of addressing the real issues. They could have filed the pro se only instead of talking about my defense to sabotage my trial by a judge. Sorry. The reason I say the son that it doesn't exist is she references this son. Oh, she does right here. Okay. She's not talking about Al Stauch. She's not talking about Gannon's dad in this. She's referring to a biological son that she claims exists. I've not seen any record of any children that are biologically hers outside of Harley, just so you guys know. Defense. Indeed, I am innocent, but I will not put myself or others in danger of running the defense against my biological son when the system is letting two men run free who are involved. One is a prominent member of an independent business. They use the NGRI to get a hearing, knowing that I'm not guilty, to cover up their lack of representation. Although I had bouts of insanity and still do, I did not murder or abuse anyone, nor would I. Nor would that be a defense, because it's my understanding that you actually did do it. However, I will protect my bio son. I will protect the drugs and violence documented by my stepson. The truth is, the court is holding the wrong person for the wrong crimes. This whole process has been nefarious, from denying me an attorney, threatening me in the bathroom away from cameras to confess, taking advantage of me, being delusional, threatening my other kids' freedoms, or else. I am going to keep making it known, sir, just how much the state has done in this wrongful incarceration. I will continue to be an advocate for myself, because I am not a murderer, and the level that the prosecution goes through to promote a wrongful conviction is absurd. Yes, her rights again. I got it. That's so funny. Now she's speaking for the other inmates. Yeah, she is just out here trying to make sure that everyone has no constitutional violations. Okay. Truth is, they could see a video from someone else and they would dismiss that person as a lunatic. They have far too much invested in this wrongful incarceration to admit they were wrong. For these reasons, and because my defense team is in cahoots with them, I am left with no other choice but to represent myself. Denying me my rights under the Constitution has happened throughout this process, from the detectives, the jail, and now my legal team. Every day I'm getting worse mentally due to inadequate representation. I'm being held hostage for a crime that I did not commit. These are my conflict issues and my reasoning for asking to go pro se. As always, thank you for your time. Scribble. I'm sure it says like Dr. Letecia Stauch or something along those lines, but there's the little letter. She's a handful. And then it just keeps going, right? She just keeps on keeping on. So she goes pro se, right? And she refuses to go to the law library a couple times. This one here is about that. It says on April 2nd at 8:25, I entered the jail cell of inmate Letecia Stauch to personally notify inmate Stauch that her refusal to attend the law library program would result in a suspension of the privilege. Although Miss Stauch knows who I am, I identified myself to her as I was in civilian attire. I was wearing a K95 respirator mask, and I told her I really wanted her to take advantage of the law library program she had refused to attend recently. Miss Stauch repeatedly said for me to take me off the law library list and that she didn't need the law library. I told her her refusal to attend would result in a suspension for 90 days. Miss Stauch stated that her reason for refusing to attend during the hours we specified for her was because of medical concerns. She was concerned that her drowsiness would interfere with her in the early morning hours of her law library slots. I told inmate Stauch that our medical staff could address her medical concerns to better fit with her assigned law library schedule. Inmate Stauch began to argue about her specific medical conditions and asked if I expected her to, quote unquote, sleep all day. Again, I told her it was in her best interest to participate in the law library program as a pro se inmate, and we could address her medical concerns and work with her at the law library times. She again said she didn't need the law library and thanked me for my help and told me to take her off the law library list for a third time. So she's just a handful the whole way around, the entire time she has been in there. And keep in mind, the reason that she was under such strict security and was being, quote unquote, abused by these guards and different things like that was she tried to escape during her transfer from North Carolina, South Carolina to Colorado. She also tried to escape whenever she was in the jail. So she has a huge flight risk. I'm sure she is not a willing participant in much of anything they ask her to do. And it's just been a lot. Hi, The Struggle is Real. How are you today? Oh, it's okay. I get it. I appreciate the laughs. I really do. Honestly, it's just a lot to go through. Like, with everything else that we've looked at too today, it's just been a lot of heavy. Whoops, I didn't mean to go back that far. Sorry that I do that noise. BC told me about me doing that noise recently, and I don't know why. It's just part of like whenever I'm searching, I like make a noise. Just like my scrolling. Here we go. All right. I don't know. There should be like one more, I think. Let me double check that they're not back real quick. Or turning on the WebEx, I should say. No, not back yet. You don't need to understand the law as a defense in your defense if your defense is insanity. True, but at that point, she wasn't doing the insanity plea. Of course, then again, she kept saying she had an ace in the hole and she wanted them to get her medical records. Maybe she went into this the whole way, planning DID from the beginning. If that's the case, then that would be why they didn't agree to her defense strategy, I'm guessing, from the what's that called? Public Defender's Office. If we can find a couple of these videos from her trials. Here was her at her first court hearing ever, so that she could waive extradition. Oh, maybe. Let me see if I can get it. So you guys can see, for those of you who haven't seen her in court yet. My goodness. Her public defender, whenever they released her, she looked so freaking relieved and like literally rolled her eyes, everything. Like she was just done with her. Here, let's watch this one first. This is her extradition hearing, just so you can see. Okay, so this is literally right after she was first arrested. Let me see if there's a date on this. Right after she was first arrested, okay? March 3rd. So she was arrested March 2nd. So that's 2 months almost from when she killed Gannon. And so we'll see how she looks throughout the different hearings to see if you think, does she look like she's representing a different personality throughout these videos?
Is this Miss Stauch? Stauch? I knew whichever way I went, I'd be wrong. But okay, I don't know how much you know about the extradition proceeding. Do you know anything about extradition? Well, you're going to learn. This morning, you have a decision to make. You can either waive extradition, and the state of Colorado has 20 days to come get you, which, to be quite honest about it, under the facts of this particular situation, I have a feeling it'd be much shorter than that. But anyway, they'll have 20 days to come get you, or you can fight extradition. Fighting extradition means that, and this is a guesstimate on my part, that it would be about maybe 90 days from now, the Attorney General from the state of South Carolina would hold a extradition hearing where he has to prove two things: that you are Miss Stauch, Miss Stauch, and that you are wanted for a felony in the state of Colorado. It's not a very high bar for them to jump over, but that is the standard in a extradition hearing. So my question to you is, do you want to waive extradition or do you want to fight extradition?
So when you said something about fighting it, I have to do what now?
Well, you don't have to do anything. You just have to sit until the hearing comes up. But otherwise, the state of Colorado has, if you waive extradition, they have 20 days to come get you. I would be surprised if they weren't already in the air, but that's just me. I have no factual basis for that, but I'm just.
They were here yesterday. That's who actually came.
Oh, okay. So what you want to do, young lady? You want to waive extradition or you want to fight?
So if there's a hearing here, what does that mean? They decide to determine what? If the hearing is here, what does that decide?
It just decides whether you go back to Colorado or not.
Well, I've still never been given the opportunity, like since the beginning, to even call my attorney to even talk to him about any of these things.
Well, where's your attorney?
I need to call my friend Laura, who has an attorney, but I was told yesterday that someone was going to do that, but they never did.
Okay.
I've asked since yesterday that I call an attorney.
Well, it doesn't matter either way to me, because I'm just asking the question. I don't care what the answers are. If you waive extradition, I will sign the extradition order and they'll bring it back there for you to consent to. If you fight extradition, then they'll just have an extradition hearing sometime in the future. And the problem with fighting extradition is that the time you spend sitting waiting for the extradition hearing is always considered to be your time, not Colorado or whatever the requesting state's time is. So you don't get any credit. It's like, I won't say wasting your time, but, and there are very few, this isn't legal advice, but I'll tell you, there's very few defenses to extradition. But it's your choice.
So you're saying it's not like a guarantee, it's just a hearing?
It's just a hearing where they have to prove you are who you are and that you're wanted for a felony. Those are the two things they have to prove in an extradition hearing. That's all. So, I mean, if you are who you are and you're wanted for a felony in Colorado, it won't do much good fighting an extradition hearing.
Oh, you're saying they have to prove that. I see what you're saying. I understand now.
Yes.
So yeah.
Okay, what you want to do, young lady?
So Colorado.
Okay, well, I'll sign the extradition order and they'll bring it back for you to consent to. Now, of course, it wouldn't have mattered if you waived or not waived. When somebody's somebody is a fugitive from one state, I don't let them be a fugitive from two states. So it's not like if you answered either way, it would make any difference as far as the hearing today goes, because I'm not going to set bond. Of course, with the charges that are involved, I couldn't set bond anyway. I don't think. Anyway.
Yeah, I didn't run from you guys. So I don't have any trouble with you guys too. I didn't even know anything until yesterday. So the date on that paper you had is wrong.
Well, let me tell you something else. And I didn't go into all this. But now that we've decided what we're going to do in this particular hearing, because of the charges you're charged with, as far as today's concerned, I don't believe I'd say too much more. Okay. All right. They'll bring the order back to you to sign in a moment. All right. Consent to. Okay. All righty.
I agree. If she does take the stand, she'll be toast. I just struggle with, okay, so she doesn't want to be present, right? She tries her best to hide from the court process and things like that. You pull up this. This is her first time appearing in Colorado, and then there is another court hearing that you can see her like literally hiding and tucking herself behind her attorneys and things like that. But this is after she arrives in Colorado, is this one.
To refrain from any audible comments or emotional outbursts. Thank you. With that, I'm going to go ahead and call attorney CR 1358, Letecia Stauch.
This one, right, Michael Allen, official.
Thank you, Mr. Allen.
Catherine
Who
Strobel.
do I have?
Sorry, Judge. Catherine Strobel on behalf of Ms. Stauch. She appears in custody.
Okay, thank you. And if you would go ahead and state your name, please.
Letecia Stauch.
And Ms. Stauch, you saw the video advisement, it went over your rights. Do you have any questions with regards to your rights? And Ms. Strobel, are you waiving advisement?
We are, Judge. We'd ask the court to set it for first appearance.
Okay. Have you had an opportunity to go over charges and possible penalties with Ms. Stauch, or do you need to do that at a later date?
Judge, we have advised Ms. Stauch of the arrest charges in this case. Obviously, when formal filing is conducted, we will do it again.
Okay. All right, so Ms. Stauch, at this point, I'm not going to read through the charges with you. Your counsel will do that at the appropriate time. I do need to set it for the first appearance. I've been given the date of March 11th at 4 p.m. in Division 15. However, Mr. Allen, Judge Warner reached out to me and asked me to find out if you were requesting the 18th instead. I don't know if there's a need for additional time for filing.
Actually, if I can ask my victims that are in the courtroom, Judge, what state they prefer, I could be fine with it.
Okay, and then obviously I'll find out from Ms. Strobel what her position is.
Judge, we're available either day.
Okay.
And Judge, we're fine with the March 11th at 4 p.m.
Okay, then this matter will be set for March 11th at 4 p.m. in Division 15. Ms. Stauch continues to be held with no bond. Anything else for today?
No, Judge. Chalmers on behalf of Ms. Stauch, who appears in custody.
All right, we're here for filing of charges and entry of appearance of counsel. But before we start, I want to remind everyone that video or audio recording is prohibited. There is a pool camera that will provide footage to the media. I understand this is a digital age. I get it. And I know that some reporters use their electronic devices to take notes, to blog, to tweet, those kinds of things. You can use them to do that, so long as it does not create a distraction and there is no noise. However, if anyone is caught recording any portion of these proceedings, video, audio, photographs, anything like that, that person will be required to leave immediately, and it may be that electronic devices will be prohibited at future proceedings. The court also understands that this is an emotional case for a lot of people. Almost all cases involving a charge of first-degree murder are. The judges in this district handle a number of first-degree murder cases all the time. This case is governed by the same rules of law, evidence, and procedure that apply to all of those cases. In addition, please remember that audible comments and emotional displays or outbursts are strictly prohibited. If at any time during the proceedings you feel that at the onset of an emotional reaction that may violate the court's order, please quietly and discreetly exit the courtroom. There is no in and out. Once you leave, for whatever reason, you will not be permitted back in. With that, filing charges, Mr. Allen.
Thank you, Your Honor. We earlier today filed the formal charges for the court system. I'm handing a paper copy to the defense team now.
Yeah, when did you do that?
It was earlier this morning, Judge. Okay, I can advise the court of what those charges are if you'd like.
Yes, because it hasn't made it out of the clerk's office yet. So when you file it downstairs electronically, it takes roughly about a day or so for it to get to us. Look at it, and it's, oh, it just got off.
Magic of the digital age.
Yeah. So I have this 4 counts, is that correct?
That's exactly right, Judge.
All right. Ms. Roll?
We have received that, Your Honor. We have advised Ms. Stauch. Sorry.
Okay.
Of the 4 count complainant information. Wait for the review or investment.
Okay. All right. And there was proceed this case because of count 1, first degree murder. This would proceed. There's some water over there.
I have some water. I'm sorry.
This case would normally proceed to a proof evidence presumption great hearing. Is that what you want to set this one time?
Judge, we're actually asking for a review hearing to be set in 21 to 30 days. Mr. Allen has let us know that it's unlikely that we'll receive any discovery in this case until 21 days from now. And so as a result, we are not in a position where we can set the case for preliminary hearing and proof evidence presumption great hearings. We also don't have access to the arrest warrant affidavit.
I'm going to deal with that one.
Right. And so we have no idea. We are not in a position where we can tell the judge.
And I know that. I know that you don't have the PC affidavit. What's going on with this discovery?
Judge, this case spanned the investigative portion of this case. It still actually is ongoing to 1 degree, but it spanned roughly 5 weeks before the arrest affidavit was given to a judge.
I have seen the PC affidavit.
Yes. And so the discovery in this case is very voluminous. We're over 1,000 pages already, based on what I've been told from the sheriff's office and the FBI. There is tons of video evidence, electronic data from cell phones and that kind of thing. So we are working. They're working on it now, and we have advised them of what that 21 days looks like as far as when we need to turn over discovery to defense. I just know that because of just the sheer volume of this case, I don't even have reports yet.
Okay, and before we get too far down that road, there's a couple of things that I need to deal with. First of all, Ms. I'm going to direct these to Ms. Strobel and Ms. Chalmers.
I'm good, Judge. I can answer your question.
Ms. Strobel, I know that there are search warrants. I've had cases in the past where sometimes they want the search warrant for proof evidence presumption great, sometimes they don't. What are you doing?
We want copies of the warrants? Is that the first question?
Yes.
Yes, we do.
Before the proof evidence presumption
Yes,
great.
Judge.
As you know, or actually as counsel may not know because a lot of them don't, those search warrants are not filed in the electronic file for this proceeding. How many warrants are we talking about?
Judge, the last number that I heard was over 107 search warrants in this case. Yes.
107.
107. I think that number is bigger than that number, though, just based on, that was last week sometime that I heard that.
Were they all issued locally by a judge locally?
No, there were some search warrants issued in South Carolina as well. And all of those were done with motions to seal as well.
Okay.
Except for South Carolina, that does not have the sealing process that we have locally.
Okay. This would be my thought. First of all, I am going to order that the PC affidavit itself, or a copy of the PC affidavit, be released and discovered to defense immediately. That I think will give them some idea about what the investigation is, what it is they think they need to have at some point in the future. You have it.
No, my request, Judge, is that the court order it be emailed to us rather than it go through the discovery process. It will just take longer. If they could email it to us, we would get it directly.
Yeah, that's fine with us because I don't know if it's actually in ISIS.
It is sealed. Okay, I'm not going to seal it just yet. That's a different issue I'll deal with here in a few minutes.
Okay. I didn't know if you could just leave it as protected so that only defense can get it. I didn't know if that was an option or not. We can certainly email it.
Probably, let's email just to make sure. That's probably the best logistic way to get to them. Because that way at least they'll know sort of where the electronic issues are, or the search warrant issues are. So email that to them by Monday.
I'll do it when I get back to the office.
Perfect. So they'll have that. All right. And then my thought was that we would set this for a sort of status conference on April 15th at 4 p.m.
Judge, is there any way we could do the week before that? I'm supposed to start a homicide trial in Division 8 on April 13th. Or I could do, I know we're taking the docket day off for that trial for April 14th, if you could do that at 4 o'clock.
Actually, before I get in trouble with my staff, which is the best staff in the building, I'll let them handle dates because I will not get it right. But my thought is that we have a status conference to find out where we are with respect to warrants
14th, which is a Tuesday. If that works for the court. Can we do April 14th in the afternoon, 3 o'clock. It is a civil week, and we do have trials.
I think it'll be all right.
If we did it at this time,
We can go to 3.
okay, so April 14th at 3 p.m.
Just for the record, that works with us and with the victim standing.
Okay, so April 14th, 3 p.m. Okay. We're gonna do a couple of things between now and then. First thing that Mr. Allen's gonna do is release the PC affidavit by email to Ms. Strobel. Second thing that Mr. Allen is gonna have for me no later than April 14th is the number on the warrants and where they are. The ones that are here are gonna be easier to access than the ones that are in South Carolina. And I wanna know what kind of warrants we're talking about in South Carolina, where it's, I don't know if it could be anything from wiretap to a search of a car or something like that, whatever.
Those were search warrants, Judge.
Well, I know that, right? A search of life. So I just need to know that, so I have some idea about what that plan is gonna look like. So we'll deal with that on April 14th. And then we should have some idea about how long it's gonna take to get these warrants released. And my read on, as I said, I read the PC affidavit. My read on some of this is that there's gonna need to be some significant redactions as a result of Chief Justice Directive 0501, because there's dates of birth,
Yes.
all kinds of personal information like that. Is that fair?
That's absolutely fair.
Okay. When we come back, if you can give me an idea about how many pages we're talking about, because it's gonna be our clerk's office that has to deal with redactions on search warrants.
So I think we're talking about, there's 2 issues with the search warrants. When we do our discovery, there will be a section in our discovery that goes to defense that will have every search warrant in it. So they'll have access to that as soon as the discovery book is put together and released to them.
Okay.
And then I'm not sure if the court is asking for release publicly on those search warrants. Yeah.
Not yet.
Okay.
I don't know if there has been a request for that. I don't know if there will be. I don't know if there will be entertaining. One of the reasons I asked that is because,
Okay.
But I don't need to have that information. But it sounds like you just released the warrants to defense through regular research.
That's how it typically will go, and it will be done on this case as well. There will probably be a separate section in the discovery packet that goes to them.
Okay. All right. Okay. And both sides have gotten a copy of the method of filing pleadings that I sent out. I think it was order 4.
Yes, sir. The people acknowledge that.
Order 02 and Ms. Strobel.
Yes, sir.
Ms. Chalmers is familiar with that because it's the same process that I use for Delaware.
I would do that.
Okay. Let's see. And there is a motion by there is a motion from Mr. Zansberg on behalf of the Associated Press to release the probable cause affidavit. Ms. Roll, have you seen that?
Yes, Judge, I found the response a couple hours ago.
Oh, okay. Well, that takes care of that because I was going to order a response to be made, so I would get an order out. The response is there, and I would give Mr. Zansberg an opportunity to reply, and then I will deal with that. One of the other things that I wanted to confirm, because it's represented in the motion, that the prosecution does not object to the unsealing of the probable cause affidavit. Is that accurate?
That is accurate, Judge. The status of the motions to seal were based on the investigation during the formulation of that investigation. That issue for us has expired, and we don't have that same concern that we had before. So that's why we have no objection.
Okay. So we have the date. Okay. I know that there are some members of the press that are here. I hope you listen to this part and follow it. We'll see. The rules in the state of Colorado govern what media access is available during criminal trials. Rule 3A of the Public Access to Information Records Rules, which was promulgated by the Colorado Supreme Court, says there shall be no expanded media coverage of pretrial hearings. There shall be no expanded media coverage of pretrial hearings in criminal cases, except advisements and arraignments. That's where we are. So the next step here, you heard that we had set a date for April 14th. That is not subject to expanded media coverage by rule in this state. The next thing that we may do after that is set up for proof evident presumption grade hearing. There will be evidence presented at that hearing, but that hearing cannot, we cannot allow expanded media coverage by rule in that hearing either. It would be helpful to me and my staff if you didn't file motions requesting expanded media coverage, since they would be summarily denied. We have to read them and issue an order denying them. But it would be helpful if you didn't do that, because by rule, it cannot be granted. I think that resolves all outstanding matters that I had. Mr. Allen, is there anything else that you wanted the court to address?
Judge, I guess just formally for the record, it sounds like defense is waiving the requirement to have that proof evident presumption grade within the time requirements.
Good point. Ms. Strobel?
Judge, we would just like to reserve our right to prove evident presumption grade at this time.
No, and
we'll wait the 35 days.
Okay, right, okay. As I understand it, I think I didn't interpret your request for delay as a waiver of the hearing. I get it. You got to see what PC affidavit and perhaps a search warrant status before you make a determination about that, be prepared for proof that presumption right here. But you're waiting the time requirements related to that. Is that correct? Okay. All right. Is there anything else you need to address from the prosecution standpoint? Mr. Allen?
Both the defense and people filed some motions. Are we going to take those up at the next court setting?
Yeah, we'll take them up at the next court setting, unless there's something immediate that you want me to answer. I mean, I looked at motions and they appear to be the fairly standard stock motions. The defense, as far as I know, has always filed in first-degree murder cases. There wasn't anything specifically directed to a specific fact. In this case, it was all preserved notes, preserved evidence, those kinds of things. So if there's something immediate that you want me to address?
Nothing immediate, Judge. I just was making sure that that's what the game plan was.
No, we'll deal with it. And I saw that you filed a response. I made sure to order on it when we get there. Ms. Strobel, from the defense standpoint, anything that you want to address?
Judge, if the court's going to issue written orders, that's fine. I think everybody's had a chance to bring up their issues. My only concern would be preservation of evidence and testing of evidence, and then be completed until the court issues orders. No consumptive testing.
Well, I thought I saw in one of the motions or the responses that you filed that prosecution's office agreed that there would be no disruptive or consumptive testing of evidence until order is entered by court.
That's exactly right, Judge.
Okay, that's typically the rule. So.
Yeah, there is obviously ongoing testing, forensic testing in this case, but we will stop if there's anything that's going to be consumptive or disruptive and seek the court's approval.
And I dealt with those before,
Yes.
So I figured that would come up if that were an issue. Anything else from you, Mr. Allen?
No, Judge, thank you.
Ms. Strobel?
Judge, I just wanted to bring up.
No, Judge, Ms. Palmer's going to wrap that.
Thank you, Judge. I just wanted to bring it to the court's attention. I mentioned this to Mr. Allen. I don't know if the court wants us to write a written motion on this. We were requesting, this has been an issue in other cases, and I think written orders have been issued. It's our understanding this case was originally assigned to Division 5, and then it got rerouted to Division 15, and we reviewed two Chief Justice orders, and it sounds like usually there's a written order by the Chief Judge about why it was rerouted, and we haven't received that. And so I don't know if the court can.
I'm not aware of that.
Okay.
But what I can tell you is, I think what happened was, as you know, all judges in 4th Judicial District are on homicide rotation.
Right.
And it's based purely by number of divisions. So first homicide goes to Division 1, second homicide goes to Division 2, on up through, I think we're 24 now. But that's how it's assigned. There is also I'm not as good as the clerks I'm not as good at the clerks at explaining this, but there's also a matrix for assignment of cases to divisions. And if I remember right, it's based on the last two numbers that are in the case number. So what happened in this case was that based on the case number only, it was sent to Division 5. Once they realized that it was first-degree murder and it should go to the homicide rotation.
Your Honor was next up.
I was just next up.
Okay, thank you for explaining that. That makes sense. We were just confused, and I know that it's an issue that people have raised in other court cases in this jurisdiction, and we didn't have any idea why that happened, but it makes sense.
All I can tell you is I was sitting there and one day I got assigned a case.
Okay. Thank you, Judge.
That's what it is. And it's about like the other homicides I've had, well, and I'm sure you've seen it where you're in one division because something gets filed, and then all of a sudden it's turned into a first-degree murder case and it gets moved to a different division.
Right.
That's exactly what happened.
Okay, that makes sense. Thank you very much, Judge.
All right. Then we're going to recess. Thank you.
All rise.
Okay, so WebEx should be back any minute now. So she doesn't technically have a public defender, like it's the public defender's office that is representing her in a way, because the state is paying for it. But her attorney is actually a private attorney normally, like Talini is. The actual public defender's office, those women that were there representing her, there was a conflict of interest, and so they were taken off of it and put somewhere else. Yeah, Letecia eventually fired this defense team. Exactly, Funtisky. Welcome, by the way. She just, I don't know. There's not very many other videos after that one, I don't think.
Court will recall 20 CR 1358 People versus Letecia Stauch. Record should reflect the jury has returned to the courtroom. I wanted to follow up on a couple of things. So I looked at some questionnaires over the break. Juror 20, you said that you had a trip planned between April 25 and May 1. Is that accurate? And where are you going? I'm sorry, you're able to what? Okay, well, you tell me, how difficult is that going to be? What's it for? What are you missing? And then juror 36, yes. You had listed different trips at different times in April and May. Is that accurate?
Yes.
Tell me about those.
I'll actually still be here, but I'll be working, for teaching purposes and then job. So competition that way is really difficult.
What kind of competition is it?
I'm a women's.
Oh, okay. And then juror 38, as I understood it, any case would be good so long as it was not in April. That, yeah, yes, aren't you the one, the tax preparer? Okay. Oh, okay. Okay, well, we have had other tax professionals in here, so that's just what I was asking about is, are you going to be really busy? Are you going to have a lot of clients missing out or what's going on? Okay. And then juror 44, the gentleman in the plaid shirt. Do I have it right that you have trips planned the first week of April in the last 2 weeks maybe of April? Is that right? Okay. And where are those trips?
One's up in Colorado, just at the around the military unit. Got a trip.
Okay. So how much so these aren't family vacations or those sorts of things. How much is this going to interfere with, if you were to miss those, how much would that interfere with your life? Okay.
It doesn't affect the wife, so, I'm not in trouble.
Okay. I understand that. All right. All right, at this point in time, I'm going to turn the questioning over to the attorneys. As I've indicated, I have limited their time, so if it appears that they're rushing through something, hold that against me and not against them. Mr. Allen?
Are you ready to engage in some question and answer? Right after lunch, hopefully everybody's wide awake. I was gonna note that, got a Browns thing around your neck, and there was a guy in Pittsburgh outfit earlier. I didn't know if you two were gonna be at Waterheads or something, if you guys stuck in the same room very long.
Browns fans that.
So that's a good example of what I want this to be like. There is no right or wrong answer in this discussion. It works a lot better if you all engage with me and you all talk more than I talk. If I'm talking the whole time, I'm not going to know much about you, and we're not going to know ultimately whether this case is a good case for you to sit on as a juror. And that's really what this is all about, is to find out other issues that make this case just too difficult for you, because maybe you've already decided because of things, or some other issue, maybe hardship. The judge talked about some trip questions that I was going to ask about as well. And so really, it's about just engaging in that conversation. I'm going to be calling on people, not to pick on anybody, but just to clarify some things, maybe that one person says and your impressions of what that person said, or some things that were put down in your questionnaire that I want to just draw out some more information on and see what your thoughts are on that particular thing. But again, there are no right or wrong answers. The only wrong answer is the answer that you hold in your inside your head, and don't raise your hand and let us know what it is. That really makes it difficult to pull on those strings. I'll do my best to make sure that I say your seat number. That's the juror number that we're using, obviously, that the judge talked about earlier. But if I don't do it, please help me remember what seat number you're in, and we'll get that on. And that's for our court reporter benefit, so that we get down accurately who is saying what here today. First question I have is, I want you to imagine in your minds Lady Justice. Has anybody not seen what Lady Justice looks like? If you haven't seen Lady Justice, raise your hand. You've never seen Lady Justice? Okay. Somebody, there's a few other hands here as well, 21 and then 72 also raised their hand saying, I've never seen Lady Justice. You also? And I think you are 39? Yes, sir. Okay. Somebody that has seen Lady Justice. Back here, number 50. Yes. Describe her for us. She's very blank. And then in her other free hand, she's got a sword as well, right? Say yes or no. Yes. Otherwise, she'll yell at me, not you.
I believe that's correct. Yes.
Okay. What do those things signify to you when you're thinking about Lady Justice?
There's
That's the first we've heard somebody talk about Plato here. We've been doing this for 5 days. So it's good that there's always a first. The most important, first, let me go back to 20 or 20. Does that sort of give you a good idea of what Lady Justice looks like? It's supposed to signify what we do in the courtroom, what the role of this process really is. The blindfold, in my opinion, is the most important part of Lady Justice. It means that when she's weighing out the facts, and that's what the scales are all about, that she disregards things like what the gentleman said about any biases, sympathy. You come in with preconceived notions, you're not going to fairly weigh out those facts because you're going to be nudging it somehow. And that's what this process is about, to see if there's any biases or sympathy that you all are having in your mind, and we all have those biases. We're all human. And we want to make sure that we get those out and talk about them and then decide whether this is a good case for you or not. Let's talk about bias. Number 31, I know you talked about having 2 different court dates coming up. There you are. Isn't it good now that the judge has excused so many people so you can sort of spread out? You're not just acting like sardines. 31, you've got a couple of different cases, including one that we're handling, correct? Would that cause any problems if we're prosecuting this case and that case as well? No, we can still be fair to the prosecution and to the defense. Okay, perfect. Anybody else think that they have any biases that they want me to ask about or talk about?
Zapier just integrated with OpenAI, and this is going to change the game for businesses and content creators.
Talk about. You don't be watching yourself stretch your nose back there, Mr. 52. I thought you were about to raise your hand. Sorry. You're fine. Who has the burden of proof in a prosecution case, in a criminal case? So which version? How about number 13? Who has the burden of proof? Prosecution. Okay. What do you think the burden of proof is? What do we have to prove? Beyond reasonable doubt. Okay, so for those that can't hear number 13, what he said is that the prosecution has the burden of proof to prove the charges that we're alleging that the defendant committed. We have to prove them beyond a reasonable doubt. Does anybody think that we should have to prove beyond all doubt? Sometimes you get that on TV shows, people saying have to prove beyond all doubt. What do you think?
No.
No.
Certain types of cases, it's way. Gather enough evidence to prove the defendant is guilty.
Guilty or not guilty. Juror number 74, so I'm trying to jump clear to the back, now. I think motive is all the way back, yep. Do you think motive is something that the prosecution has to prove in a criminal? Yes. Okay, why do you say yes? So, let's illustrate this discussion point with the example that Judge gave earlier about aroma and between the ingredient out and you don't have their aroma. In criminal cases, elements of the different charges, motive is not one of those ingredients. So is there anybody here that will have a hard time determining guilt or not guilt if we don't prove the motive?
I would think that.
Do you think it's natural for us as people to want to know why something happened? Yes. 50, sorry. Premeditation gets into intent, not necessarily motive. So motive would potentially, we have to be one at a time, otherwise we'll get in trouble. So intent would be, let's use this as an example. If I want to go to the store and buy a suit, and I want a baseball suit, I form that intent in my mind. I drive to the store, I go look in the suit aisle, find the vegetable suit, buy it, walk out, take it home, right? Those things would be intentional things, but none of that is telling you why I want it, right? I could want it because I've got a sick kid at home. I could want it because that's my favorite suit. That would be the motive, right? That makes sense to you?
I think so, but what I'm getting at primarily charge is first.
That's premeditation. Malice aforethought is a different thread that's not involved in this case. And you're hitting on some points that I think will be answered if you end up on this jury, because you'll actually get this big packet of jury instructions that have all the elements for the time to cover. Some of the phrases that you've heard before, obviously, from other at to criminal justice, whether it's on TV or whatever, are legal phrases, but are not necessarily associated with this. Premeditation with intent is, but that's an intentional action, right? Say I wanted to a football game, so I drive to the football game. Those are intentional acts to get to the football game, not why I want to go to the football game. Who here has any idea or thoughts about that? In order number 36. What's in your head as we're talking about this?
Well, I thought about separating out motive and intent that way.
And if we don't prove why to you, because we're not required to do that, and you end up on this jury, do you think you can still get to it? It could be guilty or not guilty, right?
Yes.
If you have to vote right this second, juror number 21, you have to vote right this second with establish our burden of proof, how would you have to vote right now? Okay. Anybody have a thought on that? If we had to vote right this second, and so I'm going back here to 52. Not guilty. So it's either guilty or not guilty. Why is that? So going back to number 21, we always have, this table is always going to have the burden of proof. We have to prove beyond a reasonable doubt all the elements for the charges that we charge them. If we don't put on any evidence, then you have to vote not guilty. Does that make sense? If we have established our burden of proof, so we've proven the elements beyond a reasonable doubt, what would your vote have to be done? Guilty. Are you sure? It's the right answer, but are you sure? Anybody else have any thoughts on that? Let's go back here to 61. Yes, ma'am. That all makes sense so far, what I'm talking about? Are you excited to be on jury duty for the first time?
I work in education. This is my first day.
Oh, it is? You didn't find much of me anywhere else right here? I will. All right, a bunch of you, and it's understandable why, but a bunch of you have marked that you've seen media coverage in this case. And that really gets to the points that even the judge has hit on already as it relates to you coming to this courtroom with a preconceived idea or notion that she's already guilty before we even get started. So I want to talk to some of you about that. So juror number 11. I think you'd seen media reports in this case.
Yes.
And you have a trip that you're supposed to go to Vegas.
Yes.
And you're willing to just reschedule that?
Well, it was just up in the air. It's not a
Okay.
real official trip.
Okay.
so,
Being talked about, hadn't been formalized yet.
Yeah.
And then on question 21, you said, in the question about can you be fair and impartial, you said probably not based on what I had seen on the news. So let's talk about that for just a minute. Do you think the news or the media gets everything right that they report?
No.
Do you think they're limited on how much they can actually report due to word limits?
Most likely, yes.
Okay. So do you think you've heard all the relevant facts in this case based on what you've heard in the media?
Honestly, probably not, because I haven't seen any of the real evidence coming out. Everything I've seen has been mostly social media based. And of course, you have the comments, and everyone has to give their opinion
Right.
on it. But just honestly, I know news can kind of sway us a certain way. So I just want to be honest about that I kind of have an opinion in my head already, but I haven't seen any evidence. So
Any evidence that you can consider if you end up on this jury would come from this witness stand? It would be witnesses that either saw or heard something. They'd come here, take an oath, and then they'd give testimony, or you might see pictures and videos. That would be evidence. And then what's been in the media would not be evidence. And you, based on what you know today, set aside what you've heard in the media and only base a decision on what you hear from this at a witness stand.
hard part.
It is, isn't it?
Yes, I would hope so. I want to be as fair as possible. So I know definitely now, like being on a jury, not to look at that, but so far everything I've seen has kind of swayed my opinion. But I'm hoping if I go into court, like just in all honesty, I hope I'm fair, I guess is what
Okay.
I'm trying to say.
Do you have kids by chance?
No.
Okay. Have you ever had to deal with two kids that are squabbling over something?
Oh, yeah.
Do you go in with an idea that you've already decided one kid is the instigator and the other kid's sort of the victim?
It depends on the kid.
Right, exactly. And so if there's a kid that you know is always a troublemaker, you might go in thinking this kid's causing problems again.
Yeah.
And then you find out, actually, this time that kid's innocent because you come in with an open mind. Think you can come into this case if you end up on this jury with an open mind?
I don't know. Another part that keeps going around in my head is the fact that the victim was a child.
Okay.
So like some other prospective jurors said, it's just like, it's such an emotional thing. Because I was even thinking about it on lunch break. I'm like, seeing certain evidence I might not want to actually look at just due to the of it.
Yeah.
So that's where I'm kind of tripping up is, the media, I can kind of get over that, but it's the fact that it was a child that just keeps. back to me.
So you have to tell us, you know, what's in your head and in your heart, whether you think you can be fair and impartial or not. In talking about the kid part of it, one of the jury instructions says you can't use sympathy to decide whether somebody's guilty or not guilty, right? So you can't be sympathetic towards the defendant. You also can't be sympathetic towards a child victim and make that an overriding presence in your deliberations. You have to tell us whether you think you can be fair and impartial in this case.
Honestly, I feel like
You kind of are.
honestly, I don't think so.
Okay.
I've
Okay.
just been mulling it over my head,
No.
but
Yeah,
wanted to get the truth.
that's exactly what we want. Juror 12, you had also indicated that you'd seen some media in this case.
Yes, sir.
What do you think about, based on what we just talked about with juror 11, about, you haven't seen any evidence yet? You would have to vote not guilty right now if I said we rest our case.
Yes, sir.
You think you can set aside what you've heard in the media, be fair and impartial in this case?
Actually, I lie through their teeth. They only present what they want the public to see. Hardly ever present the truth.
Okay. And so I think you said that you can be fair and impartial.
Yes.
Okay.
I have kids of my own, and if something happened to one of them, I would want the jury to be fair and open-minded.
Okay, perfect, thank you. Juror 13, you also indicated that you'd seen some media, based on the discussions we've had with 11 and 12, do you think you can set aside what you've heard in the media and decide your verdict on the evidence that actually comes into this courtroom? You do, okay. Seventeen. Also seen some media in this case, correct?
Oh, my mom's been following it.
Your mom's been following her?
Yeah.
Have you talked to her quite a bit?
Matter of fact, before I even came to this, like the day before, she was like, well, you might be on a big case, like, you know. So, but she had told me like what was going on this week, so. So. As it may that, you know, if this didn't involve a child, if it was just like a homicide, like a gang related, whatever, I could see it with equal, but the fact that it was a child really bothers the hell.
Okay.
You know, so it's not. I don't know, I already have a precognitive thought on that. It doesn't matter if the person is sane or insane, the fact is they did what they did.
Well, as you sit here today, though, have you heard any evidence in this case?
Have I heard any evidence? No, I don't know.
Nobody's gone on the stand and sworn
No,
on
this has been going on for like, what, 3 years now? Yeah, so.
And what I mean by evidence is what actually happened here in the courtroom.
I've seen it on the news, like what they showed picture wise, the bed, everything like that. Yeah, so I mean, I've seen some clip, I mean, enough to see that there is a problem.
Okay. What if we don't show you those same pictures? And so those are not actually.
If you don't show me those same pictures.
You gotta,
Oh, sorry.
hold on just a second. We have to take turns talking because she will not be able to get both of us talking down at the same time. Has anybody taken the stand yet in this court?
No.
So you haven't actually heard any evidence yet, correct?
No.
So if you had to vote right this second, how would you have to vote?
Honestly, because it's not the fact that did she or didn't she? It's she did, but is she sane or insane? That's the problem I have.
Okay. So, okay, I hear where you're coming from. So let's talk about this then. I talked about we have the burden of proof beyond a reasonable doubt the facts. Agree with that?
Yeah.
We also have the burden to disprove that she's not guilty by reason of insanity. So if they raise the defense of not guilty by reason of insanity, we have to disprove that insanity. I mean, we have to prove she's sane. Does that make sense?
Now, my bias on that is regardless if they're insane or not, they're dangerous.
Okay.
They don't need to be on the street, period. So that's where I'm standing on that.
That gets into a different avenue, and that is if you return a verdict that is not guilty, that means that somebody is free to leave. If you return a verdict that's guilty, Whatever happens to that person beyond that, guilty verdict is that man's responsibility.
Absolutely.
Not the jury's.
Right.
Are you good with that?
Yeah, no, I understand that, absolutely.
You want to move on? 20. How about you? What we talked about with the prior jurors about seeing media and being fair and impartial despite what somebody has seen. We haven't pre-decided whether she's guilty. In fact, on your questionnaire, I think you put, you don't know the facts of the case and you can be fair and impartial. Want to expand on that at all? $32. I'm gonna get you eventually. You had also indicated that you had seen news about his Gannon's disappearance and that was at the time of his disappearance. Do you think you can set aside what you've seen in the news and be fair and impartial in this case? That's the case only on what happens here in the courtroom. You have any reservations about that?
That's what? It's been a while since I saw that.
33. Have a good lunch. Must be really good. Eat about everything. You indicated that you had seen a little bit of TV regarding what the charges are, although not as much as was disclosed above, meaning what's in this packet. When you think about what we talked about with the prior jurors, setting aside what you've seen in the media, deciding the case based on what happens here in the courtroom. Do you believe that you could set aside what you've heard and decide the case just on what happens here? Six. Thank you. This topic. Media knowledge and deciding the case just on the fact.
This case is already done.
Mark, yes, on your question. What do you think? So having the idea that you thought this case was already done and then you walk in and, oh, sure, I guess the case isn't done. What went through your mind when that happened?
I figured there was more evidence than.
I think she's really asking you to shake your head.
Yeah.
38. About this media coverage topic of discussion. That's right. Do you think you can set aside that or not? Because you marked on here, she is guilty. And you haven't heard any evidence yet.
Nope.
So how could she be? How could she be?
My mindset coming to this.
Okay.
I haven't heard any other. And that might make a whole new story.
If you end up on this jury, will you listen to the witnesses and evidence? So do you think you could be fair and impartial based on what the law requires of the jury? $39, you were sort of shaking your head when she was answering your question. What was going through your mind?
I don't know. I just don't really kind of agree with everyone else that I don't really kind of already had the mindset. I really don't know if I was on the jury if I can kind of just what,
This is the time to talk about it. So do you think you would be able to set aside what's in your mind already and just follow the law and the instructions of the judge?
if I'm being honest, probably not.
Probably not?
Probably not,
Okay.
because I'm kind of set with this.
Yeah.
That's just what I think.
Appreciate you saying that.
Yes, sir.
45. We're here. Yes, how are you? How's your lunch? All right. Think about this media discussion. Do you have a clip in your mind? Yes, sir.
Yes.
Oh, that's okay. So if you ended up on this jury, would you already or only on the evidence that comes? What if you're on this jury, for one witness on the case, points about the sky was blue on. Hope that she was guilty, even though we put no evidence on about that. 57. Both almost have the same color shirt on, so I'm gonna try it. How are you doing?
How are you?
Good. What do you think about the media discussion?
Don't have this preconceived notion based on what we've seen. As a defense to
So I'm glad you brought that up because I'm gonna ask you about that as well. You indicate on here that you'd see quite a bit in the media, it looks like. And you also indicated that you believe that you can be fair and impartial in this case. That based on the not guilty by reason of insanity question. That issue as well, only on the evidence of.
I will do my best.
Any other thoughts about that? I'm going on to the darker murder in color. How are you doing? I'm doing all right, good. What do you think about the, this meeting discussion that we're having?
What's the question is if my mind she did and she's guilty. So right now I don't understand it in my mind. I definitely vote guilty.
You would vote guilty. If I said we close our case, nobody's testified, you would still vote guilty?
Well, I understand that legally I'd be vote not guilty, but yeah. I have free choice, that's what.
That's what it was, okay. 59.
Can you speak up, please? I can't really hear you.
Take advice. Take advice for lunch, he said. So far, that's the best lunch I've heard. What do you think about the media stuff that we've been talking
I Time happened, I just moved here, I just about it, my wife is all of it, there's nothing. But do you think you can decide this case if you end up on this jury? Evidence that comes here. Based on the evidence. Okay. What are your thoughts on the NGLI? You said, I see it as a way to game the system. So you've seen sort of the spectrum of mental health, some that totally out of their mind. Yes. If you hear evidence in this case that maybe the defendant was like that in this case, you'll find that she was insane. What if it's the other way that it would be very deliberate? And is that based on only what would happen here in the court? Just on that. Okay.
Of the crime and
You indicated that you can try to be fair and impartial, but you follow the case rather closely. Have you heard any evidence yet, or only me? Be able to decide the case on the only thing that decide the media. Also indicated in the master agreement. That's sort of what the previous. That wide spectrum of mental health. Not severe, so really just. Okay, how do you tell with that experience deliberate intentional acts? They are dealing with a mental health issue. If they're an impartial juror on all those issues. And that's when I say jackpot. How are you doing? Good, thank you. It used to be in law enforcement, I think, right? You're going into retirement? So you've seen some media, like you indicated a long time ago. What are your thoughts? We talked a lot about this issue. Someone said they.
That's like my kid. Wasn't on the Western Channel.
On what channel?
Western.
You also mark on question 21. It says, can you be fair and impartial? And we said no. Okay, so you believe you could be fair and impartial. Okay. And then you also mark that you plead insanity to the defense if it can be proved.
Example, there's another one on their gas. I have no use them for example. 16. Okay, 7, there was no. Now that path. Diagnosed with any of that. Back then, or that's not a kid. It's like, hey. All that stuff that occurred before.
Can you speak up a little?
He was in a witness protection program, so. By the time it got addressed.
So as a police officer, you probably also have contact with people from all over the spectrum. Do you think there are people that are dealing with mental health that can still be very intentional? Do you think you could decide this case based on only the evidence that would come into this courtroom and not what's happened outside with media or even your own experience?
I think that's where both sides. I think.
Uh, 72. That you hadn't really heard or read specifics, just. What was the last one?
Crunchyroll.
Crunchyroll?
It's animated.
Okay.
So, only time I really heard about anything was.
Okay.
But yeah, this boy went missing.
That, you could be very impartial in this case.
5 minutes, Mr. Allen.
And 74, back to you again, talking about media, what are your thoughts? Very impartial in this case? Number 14, you, how are you doing? Good. You didn't put much on your questionnaire, so tell us a little bit about you.
I'm a truck driver. I don't get much media coverage. I don't watch the media too much.
Okay.
I basically keep to myself. I have to decide on all the evidence before I make an actual.
Think you can do that and be fair and impartial?
Yes.
Okay. What about number 18? You're kind of hiding down there.
Just chilling over there, just about the case in general. Or?
Yeah, all the things we've been talking about.
I'm having trouble with insanity. All of everything on the news. Yep. What happened?
You think that potentially insanity is a legit thing in this case? Because you haven't heard any evidence yet. Okay. So the findings that you will get if you end up on this jury is you can find the defendant guilty of the charges. You could find the defendant not guilty, meaning we didn't satisfy our burden, Or you could find that she is in fact insane at the time of the offense, and so not guilty by reason of insanity. That based on the evidence that comes into this case, or are you having reservations about that?
I've been to one of these before. It's like, yeah, you watch all the TV and you watch all the TV shows and all that kind of stuff, and kind of very partial. Even when you think you're not being biased.
Will you work hard to be fair and impartial in this case? Is there anybody in this room sitting there thinking, I wish Michael would have asked this specific question because it'd be really important? Coming back to juror 57, I think.
A specific question that you need to ask, maybe one that we need to. All or nothing, guilty, not guilty, or these separate charges? That'd be found.
That's a good question. So kind of what I was talking about with juror 18, I think, that there are options for each one of the charges. You can find the defendant guilty, not guilty, or not guilty by reason of insanity for all the different charges. Each stands separately on their own. And we have to prove the elements beyond a reasonable doubt for each one of the elements, for each one of them. Anybody else have, yes, you are 27, I believe. Okay. Something private we want to talk about? So that, I'm glad that you brought that up. So basically what you're saying is that because of prior experiences, was it here in this courthouse? That's causing you to have anxiety just being. It might be difficult for you to actually listen to the witness because. She said.
Right. I wanted to follow up very briefly, and I should have done this before, and I apologize for that, but juror 16. Juror 16, you had said in your questionnaire, you said that sometimes you are, find it here. You said that you travel for work and that you are the sole provider for your home. And you said you're sometimes overseas at 2 to 3 times a month. What's it look like for you for the next 7 to 8 weeks?
I have one trip to Albania scheduled for the end of the month, but I've got an alternate I can send for that trip.
The end of this month or the end of next?
April,
okay.
I was supposed to be in Tampa this week, but jury duty.
Okay, so if you need to tell me, if you were selected to serve as a juror on this case, would that cause you an undue hardship? Would you be able to rearrange it? Tell me.
Sir, I'm expendable by definition, and as a contractor.
Okay.
So, you know, the only thing that I'm not sure of is how the company would pay out such a long jury period. I know we get 3 days.
Okay.
I'm working that with the boss right now, sir.
And I was gonna bring this up because I've had other people talk about this, and as you know, this isn't my first time with really long trials. And I was surprised. There are a number of employers that continue to pay jurors, and a number of private employers, USAA, I think Target, Walmart. I'm trying to remember some of the other ones. So yeah, the post office, right? So so check with that, and if you come back, that'll be one of the questions that we'll ask. Okay.
Yes, sir. I didn't say anything earlier because I don't suspect that's going to be my problem.
Okay.
I know there's another gentleman that's here too. My son is graduating from high school the week of May 15th, I think it is. His graduation date's actually the 17th of May.
Okay. That's something that we need to know as well. Do you
I
know?
think that puts us at week 7 or 8 if we started next week, sir.
Right. The 17th would be like a Wednesday. Does that sound right? Okay.
It's like 5 o'clock graduation.
5 PM?
Yes, sir.
Even if you were selected, we'll get you out of here by then, I promise. At World Arena?
No, we're at the Air Force Academy, sir.
Okay, we can make that happen. And you're 18? Yes, sir. Glad you brought it up because we are not having trial on May 12th. So shouldn't be a problem. Oh, okay. So it's not the graduation on May 12th. It is your,
Yes, for the graduation.
Oh. So you're actually out. Hold on, one of us at a time. So you're actually out the whole week of May 7th?
That's 12 is on a Friday, so that.
Right. Okay. Right, defense.
Everybody. Help this morning, but. I'm gonna follow up on some questions, that Mr. Allen talked about. This is jury selection. And the judge and myself. So, juror 16, I know the judge just cut you, but on your mental health and sanity.
Sir.
Get on your questionnaire that.
Yes, sir.
If you were picked to be on this jury dealing with this issue, then I might have some heartburn. Responsibility.
Yes, sir, I understand.
Are you going to be able to follow the law and any biases or problems you have with the insanity plea? Right?
Yes, sir. It is on their judgment or their responsibility to show where the other, sir.
Okay. And whose job is it going to be able to prove insanity? Prosecution or mine?
Prove insanity? Their job is to improve insanity. Or no, their job is to prove she's sane.
Okay. So what was it, you see that when you come in, you fill out a questionnaire, you come in and we talk for a while. And what you wrote a few hours ago was different than what you're saying. What was it? What was said that changed your mind?
I don't believe I've changed my mind.
Okay.
I believe that the insanity plea is often used as a scapegoat.
Okay.
I need to understand the evidence and hear the evidence to understand whether or not she was insane, whether insanity is a real defense at the time.
Okay.
I have not heard any evidence, so I can't say for a fact whether or not she was insane or sane at the time of the action that was performed.
Okay, so
Whether or not it was performed or not, I don't even know that. I just know that she's been charged with it.
Okay. So what you wrote on your questionnaire, you still feel the same way?
I do believe that is true, but like the gentleman in the back said, I also believe that there are times when mental illness will have an impact on what you're doing.
Okay.
What happens?
Juror number 57.
Yes, sir.
Hi, how are you, sir? How are you? I'm fine. Thank you. You wrote on your questionnaire that you had problems with insanity. It's used. Feelings on this.
See that?
Sounds like when your jury questionnaire, you had some skepticism just from.
But I know in general, once again, like the gentleman said,
My concern is, advocate for Ms. Stauch is that if there is issues, I concerns about somebody coming in. Skepticism of insanity. Have at this point right now. Okay. Said that you have a little boy and you think that. Okay, she killed the little boy. I'm sorry, I'm listening. All right, but because you have a boy, you have children, this is not the right case for you. So, Mr. Allen, we talked about Lady Justice. I lost you. Talked about Lady Justice. It looks like the Statue of Liberty. Holding the scales of justice, a sword, and a horn. If you're picked to be a juror on this case, you're not going to be walking into this court blindfolded, are you? Your blindfolds down, and you think she's.
I can't answer.
Now, back to you, juror number 57.
yes, sir.
Sounds like if you're coming into this courtroom, at least with respect to insanity, I mean, your blindfolds down. You have some skepticism about an insanity. But it sounds like you have problems with that, and especially with the insanity. Can we say, you know, the reason is we've got to kind of have a yes or no on this. I'm not trying to badger you, sir. I appreciate your time here. But, you know, if you're going to have a problem with it, then good to know now. And, you know, some, for whatever reason, are not the case for all people. Number 25. Uh, 22.
No,
22.
he's 21.
What do you think about the insanity? Well, are you skeptical of somebody who's charged with a crime saying, oh, I was insane? Are? Yes. Okay. And, you said you didn't see much of this in the media, right? Had you ever even heard of this case beforehand? Okay. And based on what, and I know what Mr. Allen and myself said during our many open. But it's a preview of what's gonna come up in the case. It's gonna be hard for you to follow through with finding sane or insane based on what you've heard so far.
I'm not going to allow that question. You can ask a different one, but I'm not going to allow you to secure an opinion from a potential juror as to how they view what the attorneys have said so far.
All right.
You can ask it differently, though.
Juror number 21, you do have concerns about. So do you think it would make it harder for you to be partial since there's allegations that it will? Juror number 36. Good afternoon, how are you? Good, good. What kind of shooting do you do? What do you shoot? Okay. Training a lot, teaching it.
5 days a week for
Told Judge Warner when he asked travel commitments that
so the then Azerbaijan technically missed that, but World Championships will be. But kind of are in there as well. Those will decide who goes to Pan American. Ultimately decide who goes to Paris, and so
this is a hardship on you and your
that
personal
would
life
be,
and your.
yes. But I figured that that was outside of that time period, so
Okay.
it'd be okay.
Okay. Hi, how are you?
Front row, far left. Yes, that's her. 31.
31. You're 31 from now on. So I know Mr. Allen talked to you about some issues that you had. I'm going to discuss that, but you wrote a question 23 with So it sounds like you have a problem in this case with an insanity. Okay, so you mentioned something that's child involved. Does that make it more difficult?
What evidence? I guess it just depends on what.
How do you feel on it tonight, Mr. We don't have to. Burden free. And on any evidence to call any. Thank you. Hi, how are you? Now, you're a retired attorney and a retired magistrate. I started in 90. Crossed right. You were leaving enough as I was coming in, so. Is there anything about your experience as a magistrate? I know you were a practicing attorney. Feel that would make it difficult for you to be fair and impartial in this case? I'm sorry, could you speak up a little bit? I'm having trouble hearing. Is there anything? No. Think you can follow insanity and follow all the rules and the jury instructions are set out by Judge Warner? Did you know Judge Warner before?
Yes, sir.
Long time. We've known each other for a long time.
Okay.
How you been? Haven't seen you in a while.
So, is there anything about, it sounds like you know Judge Warner and know him a lot. Anything about that relationship where you go, okay, maybe if he's the presiding judge, or maybe he shouldn't be on the jury in that case of this magnitude, or do you think partial is the judge up on the bench? That deep baritone voice, isn't it? Did it used to be higher pitched or lower pitched?
As I said, she's known me a really long time.
Juror number 34. You're in. Hi, how are you? Good. Are you nervous right now? I saw you do a big gulp in this swallow like. So, think you would be a good juror on this case? As far as being able to be fair and impartial with, dealing with the murder of an 11-year-old child and then people in the world. And Carolyn gave you a preview and while it's evidence, all of a sudden. Also going to be looking at autopsy photos. I know beforehand because I think but graphic evidence of very unpleasant, very hard. Why is that? Judge Warner said, you think of and I want to make this clear to everybody. I'm not trying to talk you into it. I think there's a real tendency for people who come in. So they hear Warner in his deep baritone voice. Stand active. And then Mr. Up and say, hey, so do you think you could be fair and impartial and do this and that? I think there's a tendency for everybody to want to pull in the suits, like robes on. And I come up and say, well, don't you think it's fair and impartial with the, I'm not trying to put words into you. But, you know, if this case is not the case, now's the time. Right cases, car accident, PI cases, there's a lot of different things. Oh, you've been on a jury before? No. Oh, this is your first time? I think you might be, do better on a different. You don't think you'd be. Six, right there. Did you indicate on your questionnaire that access to email.
Does the witness.
Okay, so it's not a situation where you need to check it every 10 or 15 moments. Okay, all right. All right, I got you. Number 30. So. Is. Okay. So you had middle schoolers come in who've been fighting or. Back up on the. Get back to work. Anything about. It's a. Or 13, so. This type of case, if you background in your.
Probably biases get in. Videos in.
Rather be on a different type. Made it earlier here. Okay, well. You're number 39. Good. So how do you settle a dispute? Friends or, you know? Does everybody, and I'm looking at the main jury panels, everybody agree with settling disputes? Hearing both sides of the story is a good thing? Yes. Yeah. Is there anybody that disagrees with, hey, let's hear both sides of the story? Anybody in the back here? Who thinks? Sides. Better to hear both sides of the situation. Is that the best thing? Okay. So, in here. Walk through these doors. One of those laws, rules, instruction says during this trial, Stauch. She her thinking there, you know, a lot of people's first common sense reaction or way to resolve a conflict is right away. You may. And I don't know.
Statement is, I want to hear.
Okay, and like I said, I'm a paid advocate. I didn't volunteer for this. Partners paid. Alan, though he's elected DA. Not putting any volunteer funds. We're all getting paid. Okay? Warner put it best. We're paid advocates. I'm advocating for my position and to meet. That's it. So I don't want to put words into your mouth. Also want to see, somebody that's not biased. But the fact that you're not going to hear from her, possibly.
Maybe. I want to hear, like I said, from her.
And what if you don't get to hear from her?
That's what I'm saying. If I don't hear from her, that may kind of lead me to.
Okay. Judge Warner may follow up with you after talking. That fix all the problems and make you feel.
I kind of said before, it's kind of like I'm already I'm kind of stuck in that way a little bit already, even if I hear from her. She says, so even if I do or don't hear from
So you kind of have some preconceived notions. And talk to you till we're blue. Feel what you feel. Say this is the way it's done. And I appreciate that. Oh, that's what. So, juror number 38, next to this. You expressed some concerns. Your jury questionnaire has been brought up. There was a little blurb that talks about questionnaire. Rises from the death of Tanvi Stauch, January. Whole charge. Murder. A lot of other things. Taking the body to Florida. A lot of the facts. Okay. Well, I mean, you heard Mr. Allen's opening statement. I mean, it jives what you heard. I mean, yeah, there could be some things that are wrong in the media about this. Okay. You put on question 21 that you more or less prejudge this case. Of not guilty by reason of insanity. Responsible for the care of children. Okay. You're not going to be able to be fair. After writing that. scary to me is, you said, she. I have my beliefs. About lingering concern. I'm not trying to get. My concern when it's a. And then all of a sudden. It is about whether she is.
Guilty, but now we got it.
So you don't think
I
she,
think I am, then I
no, so you don't think she's guilty right now?
I think that there's more to it than I know. The story is true. There's more to it.
But you think she's guilty right now of killing?
Not with what I know now.
Juror number 50, how are you, sir? Okay. For you. I've had a Cubano sandwich. Thanks for asking. One of the big things. What do you think about what we've been talking about, sir? You're kind of. Judge, how much time do I have left?
8 minutes and 43 seconds.
Spot me another 15 on top of that.
You have 8 minutes and 43 seconds. Actually now 34 seconds, but.
How do I feel?
case of the final juror.
Wait, council approach.
Oh, who's in trouble? Council approaching. Not even to the end of the defense's time. I wonder if they're going to immediately delete somebody. That's what they did last time. Sorry, we're playing hide and go seek over here. We seen that. It was edited though. Like it's not real. We actually have seen the photos that she took that from and put that image over it. But it wasn't like a real
Go ahead.
thing.
So at some point, maybe, you know. You're the juror. I'm asking.
And she said, we don't know. I agree right now. Say, but he's disputing. So I'm concerned.
That's
What they like.
that's not accurate. Not in Colorado anyway. If you're selected to serve as a juror, there actually is a process for that.
Because I'm sort of.
And again, if you're selected to serve as a juror, you would get an instruction on how to ask questions. You do not get to stand up and do your very best Perry Mason imitation. There's a process for it. So, Mr. Cook?
And juror, back over here, juror number 17. Stated that you might have some problems with this.
Well, so my problem with this whole case is she's already been tested twice for saying it. She's saying twice. What's the third time gonna?
And
she's guilty. We all know she's guilty of what she. but I feel like it's placating them.
You have about 1 minute.
Anybody here? 17. Show of hands. Anybody?
Wrap up, Mr. Cook.
Leave it at that.
Right, thank you. Aside from juror 33, does anyone else know either myself or a member of my staff? All right, and okay. Even though you've been questioned by me at some length, you've been questioned by the attorneys as well. The question that I have for all of you is, do any of you have anything lingering in the back of your minds, a question in the back of your minds where you're thinking, you know, they didn't ask me this specifically, but I think this is something that they would want to know before they decide whether I should potentially serve as a juror in this case. Anybody have any of those kinds of issues? You have one hand. That would be juror 64. Yes, sir.
Seriousness is even one thing.
No, that's actually okay. And some people do and some people don't. And I think there was, it was juror 59 said that he had recently moved here and hadn't heard anything about it. So, and some people who have lived here in the community for a long time haven't heard about it, or they heard about it and it was long enough ago that they don't remember it, or they have sort of put it aside. So that's what I think that may be the difference. Anyone else have any issues? Juror 39, yes, sir.
Kind of like a personal thing for you guys to know, before you do. I have ADHD, so I have to keep focused on a task, you know? So I feel like with how long this jury is, it may not be.
Okay.
I also have dyslexia, so if there's a lot of reading and stuff, that'll put me at a disadvantage. Put me behind everyone else.
Okay. All right. All right. Anyone else? Well, that worked. Okay. Juror 21. Yes, sir. Okay. Well, one of the things that will happen is you're going to be able to take notes. In addition, with respect to instructions, at the very end, you get a thick packet of instruction. Well, depends. But generally you get a packet of instructions. You get to keep those with you so that you'll have them to look at. Does that help? Okay. Juror 20? Yes, ma'am. Okay. All right. And juror 18? Okay. Yes. Yes, it was. And, okay. All right. What we're going to do is take about a 30-minute recess at this point in time. And here's what's going to happen. We'll excuse you. The attorneys and I will have a conference. Again, this is a jury selection process by deselection. And so when you come back, we will excuse further jurors, and then some jurors will remain, and I will have further instruction for them. But before we do that, let me make sure. Are there any jurors that believe that they could not be fair and impartial in this case that have not already, well, let me break it out. Are there any jurors who feel they could not be fair and impartial in this case? Raise your hand. All right, no response. And are there any jurors who believe that they would have to hear from Ms. Stauch before deciding the issues in this case? Right, Juror 17 and Juror 50. And Juror 50, let me ask you a little bit, because as I said, it is a trick question when they ask you that. Because here's what happens, right? You come in and they say, well, don't you want to hear both sides? You want to hear both sides, right? It's fair. That's what we've been taught since we're 4, right? You want to hear both sides. You want to be fair, right? You want to hear both sides, right? Right? That's not the law. So the reason why it's a trick question is, well, you agree you can't follow the law, right? Right? Because so that's why it's a trick question. So the real issue is, as I had explained earlier, was Ms. Stauch may testify, she may not. I don't know. And I say this to every jury that I select, not just this one, because it applies in every case. She has a constitutional right not to testify. The government brought these charges, they have to prove it. And so attorneys oftentimes go, oh, come on, you want to be fair, right? You want to be fair. And the only way you can be fair is to hear both sides. Trick question, because that's not the process that we follow here. They have the burden of proof. And so let me state it to you differently. It does not matter who testifies, and it does not matter who doesn't testify. The real question is, based on the evidence that is presented, it's always the same. Based on the evidence that is presented, can you hold the prosecution to its burden to prove each and every element beyond a reasonable doubt? Okay, so let me ask this follow-up question, because this is slightly different. It sounds as though, and I think probably everybody would agree, everybody would like to hear both sides. But in this case, would you hold it against Ms. Stauch if she did not testify? Okay. Okay. Right. All right. All right. With that, we're going to take we'll take a recess until 3:15. If I can have everyone back in the hallway at 3:15, we should be good to go at that point in time. All rise for the jury, please. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Ms. Stauch, do you need to take a break for a few minutes? You okay? All right. All right. Hey, Todd, can you run down to my chambers, get my laptop off of my desk? You'll have to unplug it and just bring it down. Can you do that for me, please? Thank you. Right. Pardon?
I think I can throw that first.
Okay. You want to do that now? Okay, we can do that now. No, it's fine. It's okay. All right. Court will take about a 10-minute recess and then we'll come back.
Sorry, guys. Had probably the grossest diaper that we've had in a while. So I was off doing that. Sorry, just trying to catch up. Okay, so they are gone for, did he say 3:15? Is that what he said? So we got 20 minutes, right? He didn't mute though. I'm wondering if they're gonna come back in and talk again. What's the now? What happened?
Oh, she was with migraines. She was. So.
Yeah, 20 minutes. Okay. I was like, what happened? What's the no? Is it because of the diaper? It was pretty bad. It was really bad. Okay. Let me see what else we can find here to talk about. What are they saying in the background? Okay, so the attorneys are taking, 10-minute break for them, 20-minute break for the jury. So good to know. Thank you guys so much. Sorry. that diaper was very traumatizing. Okay, great. Great, great, great. 3:15. Good, good, good. Thank you, thank you. So we're at 42 left. I really think at least I was trying to keep track of who was saying what, and I'm gonna say at least 12 of them are gone. And so that'll put us down
Yep,
below.
she does. Without question. My, when I was a kid, my mom used to run a daycare out of our house. And Anne had adopted, I think at the time they were 3 and 4. They might have been a little bit older, but she adopted their Indian children from Peru, I think. And they didn't speak any English or anything like that. The orphanages in Peru are not top of the line, I think.
Yeah.
And so there were behavioral issues and everything like that. And so, but my mom took care of them until they were in their teens, I believe. So, yeah.
Yeah, I can't imagine they do a very good job down there in those roles.
No.
No.
Interesting little story about the judge there. Probably explains why he has such a calm, kind, caring demeanor. It sounds like he had a great mom. Sorry, guys. I've been working on cleaning my office through while they're talking. So I've been here, but I've been like hovering and cleaning stuff up. And like my office, I don't know how many of you guys have been around for a while, but my office is also my sewing room and / craft. And I just kind of threw my computer on my sewing table and stuff, but I have totes and totes and totes of craft stuff behind me and things that I've used for homeschool and like all of that stuff. And so I'm trying to get it cleaned up and organized and get rid of some of these totes before we, are buried in them. Because as I keep going, I keep buying more and more different stuff. Like, oh, I could use that for while I'm homeschooling Junior, and I just keep collecting more and more stuff. And I'm looking around. I'm like, I cannot possibly put anything else in this room. And then my current computer, like the one before my new one.
Okay.
is
So
a
let's,
Yeah.
sorry. Yep. Sorry.
She had to use restroom, so she had to take this out.
Nope, that's okay. I should have noticed it.
False alarm, I think. I thought they were coming back. Yes, he has experienced where Judge Boyce in Idaho does not, right? Right.
I'd like to keep.
But anyways, my computer currently, like the
Yeah.
one that I had that I have that's hooked up right now, is a mini, and so it doesn't take up very much room. Well, my new one is a full size, like jumbo tower with room for expansion and all that junk. And it's not gonna fit on the little shelf that I have set up to like hold it next to my sewing table. So I have to completely reconfigure where I'm gonna put things. Because if I put it there, then it actually goes above my monitor about 2 inches. And my husband was like, "Oh, that ought to be all right though, because that way, how did he say it? He's like, you shouldn't need that bottom right corner for anything, do you?" And I'm like, yeah. I can't just not have the bottom 2 inches of the right corner of my screen. Like, no, that's not gonna work. So trying to reorganize and stuff so that we can be all set up for that to come in. We set it up yesterday and it kept throwing an error code at us. And so I reached out to them and they told us how to fix it, but I got to wait until he gets home to try it before I let them know if it's going to work or not. So, fun story. Cool story, guys.
Right. Court will again call 20 CR 1358 Pupil versus Letecia Stauch. Record should reflect the jury is not present. Prosecution, what are your challenges for cause?
So this list that I have, Judge, we all agree on this.
So these are ones that you both agree on. Okay.
I apologize if these are
Nope.
11, 17.
Let me read them back. 11, 17, 39, 45, 58, 27, 36, 18. And defense, you stipulate that those should be excused?
17, 18, 20.
We're going to do it a little bit different because I didn't get them read to me in the order. So 11, 17,
18.
hold on,
Oh.
39, 45, 58, 27,
Yes.
36, 18. Okay, all right. Okay, and then prosecution, who do you have in addition to that?
That was our list originally.
Okay. And defense, who do you have?
Okay.
Yep, just read the list.
Thirty-four. $50. 7.
Okay, hold on. Okay. As to juror, wait, you said 32, right? Uh, hmm. What's the grounds as to 32?
She was one who didn't really.
Questionnaire.
She was one. I actually talked to her. School counselor or something. This is.
Prosecution.
Don't believe that. She's not.
I'll circle back to that one. Juror 34. Mr. Cook. Okay.
She was the young lady that was in. She sent the photo. questionnaire, but it seemed.
Mr. Allen?
So what we noted down was that she doesn't pay attention much, she doesn't, and about the law. Not to be fair and partial because. I've never been a jury.
I recall juror 34, and for me, I think what separated her out was she didn't think she could do this because the victim involved a child. So I'm going to grant that one. As to 38, Mr. Cook.
He was the individual who I talked to for quite a while. They didn't do the right things to get on this jury panel. Specifically. Or was maybe. Like the rehabilitation efforts. Real estate, yeah, I stand by it. And nostalgia version. Having said.
Wait. We're on 38.
Oh, 21, yeah, I'm sorry.
No, 38.
38, question 21.
Oh.
She could have been any more plan, and I have real concerns about. And I know they get additional information and everything here, but they still know that this is the Stauch case when they're filling out this questionnaire. It's a murder case. They know it's a child abuse case. And number 19 is probably what she was questioned about. Probably the biggest concern. Not be fair, and it says Stauch case. That's usually reserved for A or B. Juvenile sex cases on children. She put the Stauch case, so I think she was trying to say the right things to get on this.
Right, Mr. Allen? 38. Sure.
Basically, she thinks partial talk. Had this last week too, where they're filling out the questionnaire in the back. Not modified. Probably more to the story than she.
I sort of agree. And I'm going to circle back to that one as well. The problem that I see with most of the arguments that are being raised is that this is a really good argument for why we should never ever use questionnaires of any kind. Because on the one hand, you have to say, well, we need to find out what they know, but On the other hand, if we're asking them questions, they've already got preconceived notions. And the idea of preconceived notions, I understand that that is a basis for the defense most recently filed motion D51. But the jurors haven't been informed about what the law is, and we've had multiple jurors that come in. And I think that juror 38 is sort of on the line that says, you ask me what I understood based on the media. This is what I think based on the media. And we've had multiple jurors come in and say, well, now that I understand the law better, I have a different opinion. So we'll circle back to 38. Juror number 44.
This is the case where they have problems. Child abuse. Is there any type?
Yeah. Do you want to take over? Or you sure? If you, no, you need to go take care of your kid. We'll figure this out. Do we need, if you want, we can take 10 minutes till he comes back. If you're good to go over, it's okay too. That's fine. It's up to you. It's your call. Okay. All right. Mr. Allen, your response to juror, or I don't know if he was done with juror 44. Mr. Allen?
So I don't have any notes about that. I don't think. But that he talked about open.
Yeah, I tend to agree. Juror 20 or juror 44 in response to question 23 says, only with respect to an NGRI, do you have an opinion? And he says, yeah, it's normally used to lessen or get out of the crime committed. And he also says, can you set that opinion aside and render a fair and impartial verdict? And he says, yes. In addition, I didn't get any responses from juror 44 that caused me any concerns with respect to his inability to follow through with his obligation to set aside any personal opinions and follow the law in this case. So everybody's going to have opinions. Everybody's going to have opinions. And that's not the question, and it's not the issue. The issue is whether or not they can follow the law, and I haven't seen anything from juror 44 that says that he can't. That question or that challenge is denied.
I'm into this number 50. I think one of the issues is the answer so far as you guys were cut out. Sandy, we would have to make a little proud of him. I think he said on multiple occasions
Wouldn't want her running around, bugging the people. And they lot of
Mr. Allen?
Really struck me as very.
Uh, Let me think about 50. Let's move to 57. Juror 57, what's the challenge there?
problems with the insanity.
Mr. Allen?
So the excuse to get out of. Questioning. He said, well, to be fair. Things he can keep. Consideration of context to.
I agree. I think juror 57 is struggling. I mean, this is, whether we like it or not, whether we want to admit it or not, this is an intellectually challenging issue, even in the law. And I think the jurors are struggling with it. And I think that they're struggling with it in part because there is, they rightly say that when the attorneys give their 2-minute mini opening statement, this isn't an issue of there's a mistaken identity, there's something else that's going on. At times, defense counsel have said that's pretty much accurate. And then it's sort of like, now we want you to think that that's not accurate. I understand that Ms. Stauch has a right and has asserted that right to require the prosecution to prove the commission of the crime itself. And that's true. And that's accurate. And she has the right and it's appropriate. I'm not saying that it's an inappropriate defense. I'm just saying that for a layperson to try and understand, wait a minute, you just told me that all of that was accurate. And now you're saying that it's not. And I'm having a hard time following that. And I think that's what the jurors are struggling with. So I think juror 57 saying that he would do the best that he could. I also think that he did not indicate anything in his questionnaire either that he could not follow or apply an insanity defense. He said that sometimes he sees the plea as an attempt to escape justice. Can he set that aside? Yes. Would he try to do his best? Yes. I think under cases such as People versus Sandoval, 733 Pacific 2nd, 319, Colorado, 1987, People versus Clemens, I only have a citation, 2013 COA 162, decided December 5 of 2013, and its ilk, those kinds of comments are accurate and they allow or they do not disqualify or serve as the basis for disqualification of a juror. In addition, you look at People versus Wolhoff, 87 Pacific 3rd, 142, Colorado Appellate, 2003. And here's one that's got almost the exact same language. People versus Griffin, 985 Pacific 2nd, 15, Colorado Appellate, 1998. That stated that a court was within its discretion to deny a challenge for cause to a juror who expressed concerns about ability to be fair, but stated he would try his best and be as fair as he could. So the challenge as to cause for juror 57 is denied. As to juror 59.
As a young man.
Yes.
So that's not an issue where you could. Concerns are that question 22. Neighborhood. Out houses, white school. Three issues I see. Also, is a and Stauch. He would have to. He is actually insane, then it becomes a prosecution.
Mr. Allen?
Without a doubt.
Sorry.
Without a doubt were his words.
Mr. Allen?
Judge, I have a completely different memory of the discussion. That, yes, he could be fair and impartial, and then put out evidence is impartial and a fair trial is a constitutional. That he nothing about seeing blue lights on the house was indicated. This is working with people. Issues. Higher working. Talked about having seen a wide spectrum of cases, that there are cases that would rise to the level of insanity, and then
That's kind of what I recall from him, is that he had seen a wide gamut, and he thought in some cases it was people trying to game the systems, and in other circumstances it was legitimate. And I think that's probably fairly accurate. He said that he would be willing to listen to the evidence. He thought he could be fair. He thought he could be impartial. I think the mere fact, and this is the gentleman that doesn't really know a whole lot about this case because he's only been in the community about 3 years, 3.5 years, something like that. So I'm going to deny the challenge for cause as to juror 59. Wrapping back to juror 32. What? No, we've already made argument on it. I said I was going to reserve ruling on it. The impression that I got from her, and I don't know how to describe it necessarily. I think what causes me more concern was the way that she sort of volunteered, or sort of kind of put out there. What did she say? Was I would have trouble with the bad things, or the gruesome things, or the gross things, or something like that. And the impression that I got in watching her face when she said that was that, and I've not seen them, but I understand the autopsy photos here are pretty bad. Okay. And I just think that I think for her, I think the impact is going to be too significant. And as a result of that, I'm going to grant the challenge for cause as to juror 32. Grant. So, I've granted the challenge for causes to juror 32, 34, 38. Again, I think that she decided these issues based on what she knew at the time, without having been advised of what the law is, without having thought about it in the context of what the law requires and what the law is. And I'm going to deny the challenge for causes to juror 38. I have denied the challenge for causes to juror 44. I'm sort of borderline on juror 50. I think that Mr. Allen sort of hit it on the head. I think he's an intellectual and he's looking at it from an intellectual standpoint. And so I think we could have some really interesting conversations with him. But I think given all of the circumstances, it is close enough in my mind that I am going to grant the challenge for causes to juror 50. So let me work through this. All right, so the jurors that I will be excusing are jurors 11, 17, 39, 45, 58, 27, 36, 18, 32, 34, and 50. So council, approach and check your sheet with mine. Do you agree? Both sides agree? Okay. All right. All right, let's go ahead and bring him back in, Todd. Thanks.
Yes,
Do you
I
agree? Thank you. May all be seated. Court will again call 20 CR 1358. I wanted to have one follow-up conversation with juror 59. Tell me what all you have to get done between now and the end of May. Okay, that's exactly what I wanted to know. Thank you. Get you a letter. I'm going to do the jurors who will be staying with us. So if I call your number, stay here. Back to the jury assembly room. Right. Yes, ma'am. And this is from juror 30. You were juror 30, right? No, 31 was the one sitting next to her. Oh, I'm sorry. Yes, juror 31. Right. Okay. Yes, go ahead. We'll deal with that. It'll be okay. And if you need something from me by then, as we get closer to that, just let us know. But we can deal with that. Okay. Oh, that's right. Yeah. Okay. All right. Here's what we're going to do. I'm going to have Mr. Combs and Mr. Sproul are going to be handing out some information to you. What we have been doing is, this is, I think, day 5 on jury selection. We plan to get to a group of about 110 or so that we will be bringing back on April 3. At that point in time, we will be selecting our jury from that group of 110. You've probably guessed that there's been some public or media interest in this case. There could be more between now and next week. Guard against that, as you'll be required to decide this case based on the evidence presented and the instructions that I give to you. One of the first questions I'll be asking about, is there anything that has changed since between now and then that would cause you a difficulty in serving as a fair and impartial juror in this case? So your friends and things like that who want to tell you all about this, say, no, I can't do that. The judge said I can't do that. Remember that. Just say the judge said I can't talk to you about this case. You can tell them that you're on this case. You can tell them how long you think you will be on this case. You can still blog or communicate with others, just not about this case. You can't do any blogging about your jury experience or communication with other jurors. You can still watch TV. You can go on the internet. You can still shop on Amazon. You can still do all of those things. You just can't do anything that has to do with this case. So, Mr. Cook, can I get you to sit down for a minute so I can see the jurors? Thank you. If anything comes through your feed regarding this case, change the channel, swipe right, swipe left, up or down, whatever it is that you have to do to get to a different page. Just don't read those articles. Don't pay any attention to them. You're not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television and radio broadcasts, dictionaries, medical, scientific, technical, religious, or law books or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia, blogs, and other websites. You're not allowed to do any research about this case or this kind of case. So what will happen is we will bring everybody back on Monday, April 3. We're going to bring back some of you. You guys will be coming back at 11. We have others that are coming back at 9 o'clock. And we're going to start sort of a truncated process like what we've already done. It's going to be a lot shorter because the attorneys have already had an opportunity to talk to you. Everybody that's here has already said that they believe in the fundamental principles, such as they can be fair and impartial. They can grant the presumption of innocence. They can follow the jury instructions. They're not going to hold it against Ms. Stauch if she asserts her Fifth Amendment rights. So that means that you've been qualified to be part of the jury. Whether you're ultimately on it or not, we don't know yet. So we'll have you come back on April 3, and we will determine all of that. What Mr. Sproul and Mr. Combs are doing is giving you a card. Keep that card. It's important. Number one, it has your return date and time. Number two, it has contact information for us. So if something happens, such as we've already had some contacts from jurors, one lost his job, and that changes his financial picture. Another juror had an emergency in the family. So if something like that happens, you need to call us and let us know. I will tell you, as much as he might want to, and as much as he wishes that he could, the law does not permit you to call Mr. Sproul and have him say, okay, you're done, you're off. It's up to me. You have to come back on April 3. It's something that I can hear then, but I most likely cannot decide before April 3 because everything that has to deal with jurors, I have to discuss with the attorneys first. So that's the reason behind all of that. It may take us a while to get back to you. We haven't forgotten about you, I promise. So anybody have any questions about that process or my instructions so far? Juror 63, yes, sir. There you go. You can blame him. That's his fault. Juror 74, yes, ma'am. I'm glad you asked that. Thanks for reminding me. Number one, you do need to come in the public entrance. Number two, you do not need to go to the jury assembly room where you went this morning. Meet in the hallway, and we'll have somebody out here. In addition, because there's going to be a number of you, please be mindful and respectful that we have other business that's going on in the courthouse and this hallway. So there's going to be a lot of you out there. Please don't make noise or be talking loudly, because there are 2 other courtrooms that are in this hallway that will be conducting business. But yes, come in the public entrance, come to this hallway. Okay? Does that answer your question? Perfect. Juror number 12. Yes, ma'am. Yes. Any other questions? And you should have, do they have a QR code for that? Or are we waiting? Not yet? For the pass, because we're only worried about the 1 day. Okay, yeah. So you should have a pass, so it'll be like you had for coming in today. Okay? Anything else? No? All right. And do we have all the contact information? No, we're working on that. Okay. Okay. So we'll give you a couple of minutes. This information that you're giving us stays only with court staff. It is not given to the attorneys or anybody else. It's just a way for us to be able to contact you if we need to, if something changes. Yes. Juror 44. Yes, sir. Um, is it too high? Is it what is lifted? What is the height? I want you to contact Mr. Sproul and tell him. My guess is there's probably not a workaround to get you in a garage. There may be a workaround to do something else, but it won't be a garage. Oh, I didn't think you could get your truck in the garage. Okay. We, give Mr. Sproul, contact him, find out, tell him exactly where it is that you are. I think there's probably something, I'm just not sure what it is. So you can't get your truck in either, and it's because you, okay. Thanks for bringing that up. That's an unusual one, and I will follow up on that. So stay in touch with us. Juror 44, like maybe this Friday or actually Thursday, give us a call, and we're going to try and have an answer for you. Okay. Do you have another car that you could drive? No, we're not going to do that, because I'll say that, and we'll end up with 3 feet of snow in April. So, okay. No, we'll figure something out. I'm pretty confident there's a workaround. I'm just not exactly sure what it is. Thursday. Call Thursday. And we may be in and out because I have other docket matters, but call Thursday, or you have an email, right? Okay, we may be able just to let you know by email. While your truck is lifted and won't fit, is it longer than standard? Is it also longer or just taller? Oh, okay. Got it. Okay. So you can fit in a regular, you can fit in a regular space on the street if that, okay, all right. Okay. Okay, so follow the instructions that I've given you. We'll see you all back 11 o'clock a week from today. And we will have further questioning at that point in time. Again, don't discuss a case among yourselves. Don't discuss a case with anyone else outside of the guidelines that I have already advised. And we'll see you a week from today. Thank you all for coming. All rise for the jury, please. Right. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Because we have one more day that we're going to go, I think we're going to end up with everybody that we need tomorrow. So I want you guys to think about this overnight, and we can talk about it tomorrow. My thought is that April 3 is sort of a flex day with no evidence. And by that, I mean, I think, I don't know how the jury selection is going to turn out, but worst case scenario, well, not worst case, next to worst case scenario is that we don't have enough in the initial 75 and we have to bring in the other ones. I think you're entitled to see what that looks like before you start exercising all your peremptory challenges. And so it's conceivable that we wouldn't have a jury until the afternoon of April 3. Once we get done with that, I have to talk to them about how they're going to get into the building, how they're going to get into their jury room, all of that kind of stuff, and give them admonitions for it. So I would anticipate that we can get to openings. I'll give each side an hour for opening statements, but I'm not going to be unhappy with somebody if they don't have evidence on a week from today and all we get done is jury selection and opening statements. So that's up to you.
That sounds fine to us, Judge. Sounds like there's maybe some that have already reached out.
Yeah. Oh, yes. I'm glad you brought that up because there are comments that I want to share with you that we have from the jurors. My thought is to wait until we get closer to that so that you're not having to remember in between for the next week. But we have probably about 3 comments. I think we've had 3 that have responded, and you're entitled to know what the communications were. I don't have a problem with that. I think you'll probably want to know what they were as we get closer. Maybe be here 8:30 on Monday morning, and I can tell you because it won't take long. I'll tell you what all of them are. So
Are you anticipating
go ahead.
Allowing us to question the panel?
I'm thinking probably not, unless it has to deal with a change in circumstance, and it depends on whether I'm going to excuse that person or not. If there's some change in circumstance, a juror were to come in and say, I saw some story and I didn't realize until I was in it what it was, and I just can't put it out of my head. I might allow some questioning about that, but again, I intend to go back through hardship again, secure that nothing else has changed. So if I allow questioning, it's only going to be in changed circumstances from what, last week to next week, and that would be it.
So very limited, just to have specific.
Right, right. It's all, yeah, if there's any, it's going to be limited to those specific jurors, and that's it. Mr. Tellini? Okay. All right. And the hardest part is going to be if we don't have at least 50 after excuses at 9 o'clock. Because then I do think, because then we got to do the other half. And I do think you're entitled to see all of them in one shot before you start exercising your peremptories, because you may want to see how that shakes out. And I think you're entitled to do that. So that's just a matter of logistics, and that's where I could see something taking a little bit longer. That's why I think it's probably better to wait for presentation of evidence until Tuesday. So I don't know. I hope that doesn't throw your schedule off, but okay. All right. It is what it is. No, I understand. Okay. All right. Court will be in recess then. Thank you.
Wow, we are done. Okay, so one more. We'll see you guys tomorrow. Yeah, hour each for opening statements. We will hear that on April 3, which is great. I was wondering where you had confirmed it from, allegedly innocent, Jules. I had seen the person that you're talking about flying around Twitter, and I wasn't sure if it was actually that individual or not. Let me see. From what I understand, the person is a Twitch streamer. So I'm wondering if it was targeted that way because of, if this truly is somebody, maybe because of the religious principles there, but it's just absolutely upsetting. Yeah. Yeah. Off to the races, April 3, we have a jury pool. You know what though? We're still gonna be here tomorrow. No, I thought he said that we were gonna get the rest of what we need tomorrow. He definitely said that. So they are planning to have one more day still. One more hangout, you guys. And then we can start actually getting justice for Gannon. Let me see. Is that who this is? Let me double check what their name is. I'm not sure. Yeah, he's making them get 5 more. But if you heard him, they did say that there was a couple. He said that there was a couple that have already called back in and their life has already had a change. And so at least they're going to be able to replace those ones on the very first day. Because it sounds like, out of the 75, and like he said, they need to have 50 there to have the lawyers be able to pick from. So We could be sitting from 9 to 11 just waiting for the 11 o'clock people to come in so that they can have a full pool, which would suck. Oh, that would suck so bad. To just have a day of nothingness, which I guess we can be prepared for that just in case. I'm sure we will be able to hear the actual jury selection before the opening statements and stuff happen. Yeah, shooters leave so much wreckage, so much. But I don't know, you guys. I'm gonna go. I'm gonna tell you what happened real quick while I was away. Right, I'm in here. I'm cleaning up my office and stuff. The kids are out working on like an arts and craft project. I gave them some things so that they could cut and paste and color and stuff. They're at the table like right near me. They have a little table and stuff, and then a whiteboard set up where they color and all those things. And that's why you guys can periodically hear them throughout. And all of a sudden I hear my son yell, "No!" And I'm like, "What happened?" And I turn and look, and Junior is holding a chunk of her hair. Junior just cut a chunk of her hair out. So I'm like, "Oh my gosh." Thankfully, it's like towards the front where her bangs were already, and so it should be easy to fix, but ugh. I almost cried, but I know that whenever I was her age, I cut the front of my hair and my brother cut the back, and it was literally like 2 inches long. Yeah, you could cut paper, you don't cut your hair, right? No more. Or no, you don't cut Peach's hair either. We don't cut the dog's hair either. So yeah, Peaches doesn't need a dog haircut, so. Oh man. But yeah, so that was my little fun for a couple minutes there. Let me check on
For Valentine's Day. This chunk of thing for Valentine's. I got added in Valentine's.
let me see if they have confirmed it. Just want to check because I know that there's names circulating. But I'm not sure. Not sure if they have confirmed it by all 3 of the children that are deceased from today's school shooting were 9 years old. Evelyn. Let me show this. Yeah, the first self-hair trim. Yes. Let me show this real quick before we go, since we did talk about this for a little bit, and look at this. So the suspect is believed to be a former pupil and was armed with at least 2 semi-automatic rifles and a handgun. The shooter was herself shot dead by police after an attack that unfolded over 14 minutes. You know, I'm just going to say, and not to diminish the children and adults that lost their lives, but I am extremely thankful that this lunatic wasn't able to harm more individuals in that 14-minute period. It's very clear with the multiple weapons that she was likely intending to harm more, right? And she was only able to get to 3 adults and 3 children. And I am thankful that whatever happened in this time frame, that they were able to stop her beforehand, but also whatever was going on, that she wasn't able to get access to more children in that 14-minute period. She had maps of the school too. So the children, their names are, like I said, they are 9 years old. We have Evelyn, I want to say Diakos, I don't know how to say that. Haley Scruggs and William Kinney. Sorry, my phone just started ringing, so I was trying to mute it before it like blew off you guys' eardrums because it was sitting right next to my thing. But the 3 children and then the adults were Cynthia, Peak, Catherine, and Mike Hill, 61. From what I understand, he was a janitor that let her in. Is that correct? And then the shooter's name is Audrey Hale. Sorry, it was my husband. Yes, Audrey Hale is the person that did this. Your little person cat is named Peaches. So yeah, prayers for the family, for all of them, and for everyone who witnessed and heard it and all of that, right? It's a lot to handle. So keep these victims, guys, their families, and everyone in your prayers and thoughts. And I am going to go ahead and jump off here. My husband is out in the driveway and needs some assistance. So that's who is calling. I love you guys. Thank you all for being here, and I'll see you all tomorrow, if not sooner. Bye.